recorded live.
Well, welcome everyone to the call. My name is Matthew, and I am running the show tonight, and our host is Christian Walters. And without any further ado, Christian, I'm going to turn it over to you so you can do the disclaimer and roll right into the meat of the call tonight.
Okay. Can you hear me, Matt? Okay?
Yeah, you sound great, Christian.
All right. So take notice and acknowledgement and agreement that this show and or documents is private, not to be construed or relied upon as being legal advice for an individual legal situation or employed for making legal decisions. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved, without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein referenced, and has no interest in any issue referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. Okay, can you still hear me okay?
Yep, you're good. Go ahead.
All right. I'll just get my voice into shape here. Should have done some warm-up exercises before. All right, where are we at here?
Where are we starting?
Matt expressed that we were in the Gilbert's Law Summaries book, and we're going to start on page 30. Under Section D, Parties to the Trust. So that's page 30 in Gilbert's Law Summaries on Trust. Parties to the Trust, Section D. So number one, settlor, or the trustor, or the grantor, if you want to call him that, under Section 112. It says, in general, a person who owns a property interest may create a trust with regard to it and become a settlor. Next page, 31. Capacity. Section 113. A settlor's legal capacity to create a trust is measured by the same standards applied to like non-trust conveyances. The same standards as like non-trust conveyances. So thus a settlor of a testamentary trust must have testamentary capacity, and a settlor of an inter vivos or a living trust must have capacity to make a similar type of non-trust inter vivos transfer. The settlor of a revocable inter vivos trust must have a testamentary capacity because such a trust is considered to be a will substitute. The settlor of a donative irrevocable inter vivos trust must have gift-making capacity, and the settlor of the trust established as part of a commercial transaction must have contractual capacity. Number one, voidability, Section 114. Legal disabilities, example, minority, mental incapacities, and remember your actions can determine your mental capacity or incapacity. So mental incapacities may render the settlor's act void or voidable. with the same consequences as any other void or voidable conveyance under applicable or appropriate local law. But continuing on, under certain circumstances, trusts may be created or amended by conservators or holders of durable powers of attorney on behalf of settlers under disability. 2. Qualifications, Section 115. In general, to have testamentary capacity, a settler must, 1, be of legal age and to make a will, and 2, suffer from no derangement or insane delusion that affects the testamentary disposition, and 3, be able to understand the nature and the extent of her property, the nature objects of her bounty, and the interrelationship of these, and to formulate and understand the disposition she is making. The settler or of a donative of irrevocable inter vivos trust must meet the gift standard, which is generally less settled than the will standard, but which is probably the same as for wills with respect to mental sufficiency and freedom from derangement affecting the transfer, and further requires the ability to understand the likely effects of an irrevocable transfer upon the future financial security of the settler and dependent family members. So this kind of brings in the capacity we talked about on some other shows. In fact, we'll probably be getting in that section a little bit later on page 33 here of the trustee. But it would apply to generally anybody because we're talking about the settler or the trustee, or really the beneficiary. And that is that, if we're jumping ahead a little bit here into section 127, let's back up to 126 on page 33. So we're jumping ahead a little bit here. But the capacity to take and to hold the title. So what this section really boils down to is that any dummy can acquire and hold property. That's what that whole section is going to explain, and we'll get to it. And then down on to 127, the capacity to administer the trust. What that boils down to is not every dummy can administer the trust, because that section is talking about incompetence. They have an incapacity, and they have no skill, no understanding, and they lack capacity. So that would be qualifications back in this page 31 under the section 115. So that's really what you're talking about. But it's the actions that makes you incompetent. So it's like you come walking into court on the public side, you start talking about all this private side truth, and jam it into the court, and they're going to look at you like you're incompetent. And they need a psych evaluation. So continuing on page 31 again, under section B, rights in trust property after creation of trust, section 116. So once a trust is established, the settler generally has only such rights or interest in the property as are reserved by the terms of the trust. Example, most commonly, a refrained life estate or the express power to revoke and modify or both. And that would come under section, I believe it is 345 under the restatements of the second, the law and trust. And it says, or by operation of law. And it says also to see operation of law probably under the third restatement, section 63. So hence, complete title vests in the trustee subject to equitable interest, which is the beneficial's rights and powers, and trust always operate in equity. If you look up the definition of legal fiction, you'll find out, the definition of trust, and if you look under trust, under constructive trust, it says that it's the consciousness of the court. So a constructive trust operates under the consciousness of the court in an equity. And that's really where the power of the trust comes from equity. So continuing on, the equitable interest, the beneficial's rights and powers conferred upon the beneficiaries, who may or may not include the settler, depending on the trust terms. So the beneficiary could be the settler, and then he may be also a co-beneficiary. So number one, section 117, modern trend, revocability presumed under the UTC and the UTC is Uniform Trust Code. And by statute, in several non-UTC states, example California, an inter vivos trust are subject to revocation unless expressly declared to be irrevocable by the terms of the trust. Next page, 32. Revisionary interest, section 118. Even where no rights have been expressly reserved by the settlor, if the trust or some interest in it is invalid, the res is excessive for the trust purpose, or the equitable interest may not be completely disposed of, a resulting trust exists in favor of the settlor by operation of law. And you want to see sections 111 through 120, or excuse me, 1011 through 1020. Number 3, mistake or misconduct, section 119. The trust may be set aside or reformed for fraud, duress, undue influence, and other misconduct, or for mistake, essentially upon the same ground as any other donative disposition. So, or for mistake. And that one is what I believe it's under 345 of the restatements there, where it says it was a mistake by the settlor, so he can reform the trust. So the settlor really has all the rights, or the grantor has all the rights, because he can always say, well, that was a mistake, that was not my intent, my purpose. And he can come in and reform the trust. So number 4, so no right of enforcement in the settlor as such, section 120. Unless the settlor has retained beneficial interest in or powers over the trust, in which event she has the enforcement rights of a beneficiary, the general rule is that the settlor has no rights to bring proceedings against a trustee or others to enforce the trust. This is because the settlor as such has no interest in the trust property. So once he's made the transfer. So if anybody's got unmuted, please mute yourself out. We don't get a back feed. Thanks, man. Section C, settlor's creditors, 121. Whatever beneficial interest the settlor retains, example, a right to income for life, may be transferred by her and can be reached by her creditors. So that kind of contradicts, this modern view here contradicts, as far as I'm concerned, the Declaration of Independence, where it says that we have unalienable rights. And unalienable rights means can't be transferred, period. Can't be got at. So continuing on, it says that even if the trust provides that the settlor is entitled only to such income or principal as the trustee, in his discretion, deems appropriate, case law and numerous statutes indicate that the settlor's creditors can reach the maximum amount of the trustee could permissibly distribute to the settlor. Now you might want to see section 490 on page 138. And 490 is discretionary trusts. And it says under that section that a discretionary trust is one in which the trustee is given discretion to make or apply or withhold distributions of income or principal or both to or for one or more beneficiaries, whether or not the instrument provides standards for the trustee's guidance. So that would be the trust indenture, whether if it wasn't particularly worded that said either or, they're saying that this one, if there's no standards for it, then it's per the trustee's guidance. He can do whatever he wants because it's his own discretion. So under protective trust, the purpose of the protective trust was to protect the beneficiary's assets from the creditors getting at it. So they would withhold payments and not allow the beneficiary to have any access to the payments, because if they did, the first thing that the creditors would do would be jump all over and take it. So that explains why some people are not getting their 1099 OID refunds. As soon as they get it, they're frozen. They're going to take the debt and apply it to the previous debts, and you have no say-so how it's going to be applied, because first you haven't claimed the trust and expressed the trust. And under section, 456 on page 130, what has really happened was it was a creditor's bill in equity. It says on section 456 that at common law, a beneficiary's interest is not subject to execution in the strict sense. The usual procedure was, and in many states still is, to file a creditor's bill in equity or its equivalent, alleging no adequate remedy at law, and that is that the judgment creditor had sued out a writ of execution which was returned unsatisfied. And the equity court could then decree that the trust income otherwise payable to the beneficiary be paid to the judgment creditor to the extent required to satisfy the judgment. So there goes your funds for your 1099 OIDs. And we wondered why that the IRS seized the funds or froze the account. Well, thank you very much. I'd like to know what part of the debt did you apply the funds to? Did you send me a receipt? So continuing back where we were on page 32, next section, section C, settlers' creditors, section 121. So whatever beneficial interest the settler retains, example, the right to income for life, may be transferred by her and can be reached by her creditors. Even if the trust provides that the settler is entitled only to such income or principal as the trustee in his discretion deems appropriate, case law and numerous statutes indicate that the settler's creditors can reach the maximum amount the trustee could permissibly distribute to the settler. Number one, exception, asset protections trusts, section 122. A number of states have enacted asset protection statutes that in some circumstances deny creditors access to settlers' retained discretionary interests. 2. Retained powers, 123. Creditors cannot reach the trust estate simply because the settler reserved the power to direct the trustees regarding investments or distributions to others. If the settler has retained the power to revoke, however, the cases are divided. Despite the rule as to retain discretionary interest, and despite many cases holding that creditors can reach trust properties over which the settler holds a general power of appointment, the traditional view of most courts has been that the settler's creditors cannot reach the corpus of the revocable trust. Because of the incongruity of the right in light of analogous principles, the distinct trend of cases and legislation is to allow such creditors to reach the trust corpus. So under the modern view, they're construing it. Now, what gives them the right to construe all this stuff is because, number one, you didn't express it to be a trust, so they don't know what the grantor's intent and purpose was because it's not really spelled out specifically. Because you didn't express it, you're not there defending your right as settler or grantor, and it allows them to pick up the ball that you dropped and then construe it any way they like. So continue on. This is also the view of the third restatement, section 25, section 2, subparent 2, and comment E, and the UTC, section 505A1, and has long been the rule in federal bankruptcy. Now, section 3, fraud, 124. In all states, creditors of the settler can reach the trust estate if it is shown that the trust was created by a transfer that constituted a fraud upon creditors. There's a nice cause of action there. So a fraudulent conveyance is one that is made without adequate consideration by a person who is thereby rendered insolvent, or who made the transfer with the intent to hinder or defraud her creditors. Number 2, trustees now. Now we're shifting gears from the settler. We're shifting gears. We're going to examine the trustee. So qualifications, section 125. Any person or entity who has capacity to acquire and hold property for its own benefit and has capacity to administer the trust may be trustee. And statutes limit the right of some persons or entities, example, foreign corporations, to serve as trustee. Number one, capacity to take and to hold, or to have and to hold. And I figured exactly what the pronunciation of that is. It's called like the Hammurabi Code in Black's Law. See if I can find it quick. Addendum clause, Habendum. Says number one, the part of an instrument such as a deed or a will that defines the extent of the interest being granted and any condition affecting the grant. Sounds like a trust to me. The introductory words to the clause are ordinarily to have and to hold. And you thought you were forming a marriage. How gracious it was to have and to hold till death do you part. And all along you were forming a trust with the state. Also called the have and to hold clause. So coming back into Gilbert's again, which makes me question, why did they change the word to take and to hold? Why didn't they just put in there to have and to hold? I guess they wanted to hide it a little bit. So, number one, capacity to take and hold title or to have and to hold title. In the absence of statute, anyone who has capacity to acquire or hold title to the particular property for his own benefit also has capacity to receive the property as trustee thereof. At common law, partnerships and other unincorporated associations were regarded only as aggregates of their members rather than a separate entity, and the association itself, therefore, cannot hold title to property or qualify as trustee. I'm going to come back to this. So continuing on, nearly all states today, however, recognize a partnership as an entity apart from its members, and thus a partnership can hold title to property and can serve as a trustee. Even in states that still follow the common law aggregate theory, a conveyance to the partnership may be construed as one to the partners individually. Now, going back up to where we talked about there, that the association itself, therefore, could not hold title to property or qualified as trustee. I happen to know personally of a case where an association foreclosed on a property. Now, the association came in under a corporate name, which was different from the actual association. And the reason why is right here, because the association itself, therefore, could not hold title to property or qualify as trustee. So the association itself didn't have the right to the legal title. So it had to do a foreclosure action in a corporate name, which is totally two different entities. So if anybody out there has a foreclosure involving an association that's foreclosing for association fees, say, check this section out. Number two, continuing on, capacity to administer trust, section 127. The capacity to take and to hold property as a trustee is not the same as capacity to administer the trust. Persons who have capacity to take and to hold title to the property as trustee may not necessarily have capacity to administer the trust. Thus, a valid transfer may be made to such a person to create a trust, but that person will not be able to administer the trust. That is, continuing to serve as trustee. For example, minors or mentally disabled persons may validly receive trust property and trust, but because their contracts or their acts are generally voidable, and because such persons are not likely to possess the required skill and understanding to form the trustee's duties, they lack capacity to administer an active trust, and thus will be removed by the court and replaced by another trustee. So us, by not having the capacity and understanding what they've been doing, they've removed us from the trusteeship under the co-trusteeship of, say, Geithner, the Secretary of Treasury. But you're still the trustee if you get your capacity back. If you have a mental disability, and a mental disability is going to be confirmed by your acts. So if you come into the court here and start giving this court all this truth, the next thing I'm going to do is declare you silently, mentally disabled, incapacity. In other words, you're a child, and they're going to treat you as a child and put a trustee over you of your receivership, and that person's going to have discretion over your trust. So really, you're incompetent. But sometime in the future, you can get competent. You can gain knowledge and understanding and become competent. And then you can administer your trust. And then there's no purpose to fulfill the discretionary or protective trust, because now you've come into an age where you're enlightened, and there's no purpose for the trust, for the protection of it, because you want to pay your back bills, your present bills, and don't incur any future bills. And then the purpose of the trust ceases or terminates, because there's no purpose to protect anything for it, because the beneficiary, or as to say the trustee, is paying his bills. Continuing on, page 34, number 3, corporations, domestic and foreign, as trustees, section 128. Today, all states authorize the use of corporate trustees, usually by statute. A, common law, 129. At early English common law, however, the courts refused to allow corporations to serve as trustees, in part because the chancellors believed they had no power to compel statute creatures of the state to act. So in other words, corporations. And also because of a belief that only natural persons could bear the fiduciary duty of a trust. Next, section B, foreign corporations, 130. In several states today, foreign corporations, that is, those incorporated in other states, are denied the right to engage in trust administration, or, as it is often provided by statute, to carry on trust business within the state. Down here in the parentheses it says, however, such a flat prohibition, absent some justification, may be unconstitutional. Next, section 4, co-trustees, section 131. Where two more persons or entities are named as trustees, each must have requisite qualifications. If one does not, the right to act belongs only to the ones that do. So if the trust terms or purpose are construed as required a certain number of co-trustees for sound administration, the court will appoint an essential trustee to replace one who is disqualified or dies. So the co-trustees are generally deemed to hold as joint tenants with right of survivorship. Bonding, next section B, section 132. Although there was no automatic or presumptive bonding requirements at common law, statutes in many states require trustees of testamentary trust to post a faithful performance bond. And more recent legislation trends to require a bond only if a court finds a need for it. You might want to see the UTC section 702A on that one. So number 1, courts may order a bond to protect beneficiaries' interests, section 133. Courts of equity, here we are, courts of equity again, that's where the power comes in, or probate or other appropriate court generally have the power to compel. That's the power right there, power to compel. And that's where trusts operate in equity, and equity gives the trust the power to compel the trustee. So if any type of trust or to post a bond of a particular risk is demonstrated, or if the trustee is involved in litigation with the beneficiaries in which there is a potential attack on the trustees, example for mismanagement of the trust, etc. Number 2 on the next page, 35, court may override waiver of bond, section 134. This equitable power applies even where the settlor has expressly provided that a bond is not necessary if there is a direct attack on the trustee's performance of a material change of circumstances, Otherwise, the court probably will not order the trustee to post a bond where the settlor provided relief from bonding. So a court, in this case ex parte Kilgore, a court generally may also relieve or reduce an otherwise applicable bonding requirement. C, effect of failure to name trustee or failure to name trustee to survive or qualified. Section 135. The general rule is that equity will not allow a trust to fail for a lack of trustee. And I'll quote that many times. Equity will not allow a trust to fail for a lack of a trustee. So thus, if the named trustee declines or what do they call it, disclaims. So if the trustee disclaims or declines the appointment, fails to qualify, or ceases to serve, or if no trustee is named in the trust instrument, or the named trustee predeceases the testator, a court of equity will appoint a trustee, because equity says that the trust will not fail for a want of a trustee, and the court will appoint a trustee, a successor of trustee, if necessary. And the rationale, number one, this rule protects the settler's intent. That's the whole purpose. Protect the settler's intent and preserves the trust until the purposes are fulfilled. So intent and purpose. Intent and purpose. That's one of the two elements of a trust, intent and purpose. So it presumes that the identity of the trustee is less important than the carrying out of the trust purpose. That's the whole thing. The trust purpose is the most important part. What is the grantor's intent and purpose? That's the thing I've used in the courts where I put in the footnote what it said, that it was the law of the case, whatever the intent and purpose of the grantor is. I gave 4 case sites, I believe, to support that. And this is one right here. Henry McRae Estates, 204, California, 399, 1928 case. Notice it's before 1933, before they did the flip-flop. And you wonder why they don't like those old case sites, especially the trust ones. So continuing on, number 2, personal trustee cases, section 136. In rare cases, the settler may express an intent that the named trustee is the only one acceptable to administer the trust, that is, the personal trustee, without whom no trust is desired. Here the trust does fail or terminate if the named trustee declines to accept, is dead or incompetent. Dead or incompetent. Is your straw man dead and incompetent, or ceases to serve, and the court will not appoint a successor. Number 3, caution. Without trustee, an intended inter vivos trust may fail for a lack of delivery. And delivery is a method of formation of trust. Section 137 here. It should be noted, however, that the absence of a trustee may result in the failure of the attempted creation of an inter vivos trust because the requirement of a present and effective transfer must be a present transfer and effective transfer. In other words, if there is no trustee, there is no one to whom delivery can be made, and without delivery, there is no transfer and thus no trust. And hence, the trust fails for a lack of a transfer and not for a want of a trustee. So it must be a present transfer, and it must be an effective transfer. But the trust will not fail for a want of a trustee, but it will fail for a lack of transfer. So you better have some records created that you transferred some property to a trustee. If you don't, you haven't proved trust, and your trust claim will fail. A, attempt to transfer to trustee to be named in a will, section 138. Thus, an attempted inter vivos assignment is another method of formation. Inter vivos assignment to the trustee to be named in my will, unquote, fails for lack of delivery and for want of a trustee to pass the title to at the time for the purported conveyance. With no effective transfer, there is no trust. No effective transfer, there is no trust. They would say, well, Mr. So-and-so, I don't see any transfer here to support your claim that there's a trust. B, trustees disqualified, Section 139. If there is an intended trustee to whom delivery with requested present intent is made, but the transferee is technically disqualified by law from taking title, not merely disqualified from serving as a trustee, but disqualified by law, the result is in doubt. The court may salvage the trust, possibly as a declaration of trust or by appointing a trustee, especially for a natural object of the transferor's bounty. So a resulting trust is going to form. But be supposedly, quote, equity does not save defective gifts by transferring them as declarations of trust. The question is unsettled, and the theoretical basis for a trust in such a situation is unclear. And see Scott on Trust, Section 31.5 and 32.3 on the 4th edition in 1987. C, Testamentary Trust, Sections 140. This problem does not arise in connection with testamentary trust because no requirement of delivery exists. The transfer requirement is satisfied if there is a valid executed will and the testator dies. No more is required. If the trustee named in the bequeathed or devised is predeceased, lacks capacity, or disclaims, or even if no trustee has been named, so, quote, I leave my residuary estate in trust for L for life and a remainder to R, unquote, the trust is nevertheless good, unless personal to the named trustee, and a trustee will be appointed by the appropriate court through a resulting trust. Because a resulting trust is formed, the result is that they're going to appoint a trustee, a successor trustee or a trustee, because the equity says no trustee will be allowed, a trust won't be allowed to fail for a lack of a trustee. Now the exam tip. If you encounter an exam question in which the named trustee dies, refuses to accept appointment, or resigns, remember that the court will appoint a successor trustee unless it is clear that the settlor intended the trust to continue only so long as that particular trustee served. However, an attempted inter vivos trust that does not name a trustee may fail for a lack of delivery. D, nature of trustee's interest. 1. Title to trust res, Section 141. The trustee is said to have a bare legal title, meaning that it is devoid of beneficial ownership. There's the other half of the title. That is, the trust property is held for and on behalf of the beneficiaries in accordance with the obligations of the trust. Now the source of title, Section 142. The trustee of an inter vivos trust devises title from the trust conveyance. However, the authorities are split on whether the testamentary trustee devises title from the decedent's will or merely nominated by the will, or derives title by judicial appointment confirming that nomination. The question is relevant where someone seeks to block the trustee's appointment, and the question may affect procedural matters, or whether the trust or the estate then has title. In any event, the grounds for blocking an appointment are at least the same as the grounds for removal of the trustee. B, relation back, Section 143. Acceptance by the trustee of a testamentary trust relates back to the settlor's death because the trust is treated as having been in existence from that date, the date of the declaration of the will. So an exam tip. The relation back rule is important to remember because it is impossible for a trustee, by accepting, to become personally liable or contract or tort claims arising prior to the time he accepted. And see the quantum of estate, Section 141. Usually the trust instrument will spell out the nature and the extent of title conveyance or title conveyed. If it fails to do so, the court must determine the quantum of estate transferred. And under the traditional view, in such a case, the trustee takes title to real property only to the extent necessary to carry out the terms of the trust. The modern view, based on implied powers and duties of administration, is that the trustee takes and needs the full title that had been held by the settlor in both real and personal property. In order to fulfill the duty, he must have the property, the legal title to the property, and he really owns the whole thing, but it's in for the benefit of the beneficiary who holds the beneficial title. Example, the settlor deeds to trustee upon trust for beneficiary for life. Does trustee have the fee for merely a life estate? In other words, for the beneficiary's life. And under the modern view, trustee will be deemed to hold in simple fee, or fee simple, with a resulting trust, that is, an implied equitable reversion in favor of the settlor. And under the traditional view, however, trustees will be deemed to have full legal title with a resulting trust in favor of settlor. If the trustee's power include a power of sale, which is typically the case, or if the implementation of the duties or powers otherwise requires full title, example, to encumber, so that would be to lien up, go to a lien. So absent some such express or implied power, the trustee might be deemed to have only a life estate for the life of the beneficiary with a legal reversion left in the settlor. So 2, trust estate not liable for personal debts of trustee. A, early minority view, section 145. In a few states, based on the theory that beneficiaries only had a cause of action against trustees rather than an equitable title, the trust res was subject to execution by creditors for the personal debts of the trustee. The beneficiary's remedies in such states was to bring a separate suit in equity to enjoin the creditors by proving their beneficial ownership of the trust res. Proving their beneficial ownership of the trust res. Got to prove the trust. B, the modern view, 146. Under the modern view, however, the trustee has long been recognized in all states as having only a bare legal title, no beneficial interest, and hence the trustee's personal creditors cannot reach or satisfy the claims from trust property. 3, effect of trustee's death. Death of the sole trustee, section 147. Although the trustee has only a bare legal title, it is nevertheless title. On the trustee's death, that title is generally deemed to pass to his estate subject to the trust. So thus the trustee's heirs take no beneficial interest, and the trustee's surviving spouse cannot claim dower, courtesy, or enforced share in the trust property. Furthermore, the decedent's executor or administrator has no active administrative power over the property, but probably has a duty to protect it, and if necessary, see to the appointment of a successor trustee. That may be interesting there. Sees to the appointment of a successor trustee. That might bear some checking out anyway. I'm thinking about that anyway. So the court will direct the transfer of title to a successor who then has the power to administer the trust. Number 1, note, some statutes are contrary to provide that on the death of the sole trustee, title is vested in the court or is suspended until the new trustee is appointed. So title vests in the court or is suspended until a new trustee is appointed. B, death of one of several co-trustees, 148. Co-trustees are presumed to hold title as joint tenants with the right of survivorship, and thus on the death of a co-trustee, the title vests exclusively in the survivors. The law presumes, in the absence of circumstances indicating the contrary, that the settlor intended to have the survivors discharge the burdens of the trusteeship. So if the instrument provides otherwise, or the court finds contrary intent, or let's say they construes it, because there was no wording expressing it as a trust. So, however, this presumption does not apply as a successor co-trustee will be appointed, and this may be also be done by the court if it concludes that this is an administratively more efficient or prudent. Example, where the surviving trustee has a conflict of interest, often as a beneficiary. E, disclaimer. or a resignation by trustee. So disclaiming under Section 149. So normally a trust cannot be forced upon the designated trustee. Normally. Normally a trust cannot be forced upon the designated trustee. Thus, one who has not previously accepted a trust or contracted in advance to do so can disclaim and refuse appointment as trustee for any reason, or for no reason whatsoever. And it is said, however, that the trustee cannot accept in part and disclaim in part. If he accepts at all, he is deemed to have accepted the entire trust. And this probably overstates the rule. The question likely turns on harm to trust purposes or to a beneficiary who does not consent. For example, the lower court routinely allow a trustee to accept the trust but to disclaim certain duties in a form of fiduciary powers that would have adverse tax consequences. So if you appointed the judge trustee, he's got the right to disclaim for no reason at all, or anybody else. 2, resignation, Section 150. Once having accepted appointment now as trustee, a person cannot merely resign unless the trust instrument gives this power or unless all beneficiaries consent. Ordinarily, the trustee must obtain an appropriate court order relieving him as trustee, and until then he must carry out and perform all various trust duties, and he remains personally liable for the consequences of any defaults in the meantime. So A, effect of an unauthorized reconveyance. So the trustee cannot escape his responsibilities or defeat the trust by reconveying the trust res to the settlor. So let's say that the judge sends you the documents back and says, I disclaim, So the purpose reconveyance may be treated as a nullity, or at most the reconveyance may effectively return legal title to the settlor, with the beneficial ownership remaining in the beneficiary. The settlor would then hold title as constructive trustee for their benefit. So until the court appoints a successor trustee, say, so that the settlor has the trustee transfers the res to the new successor. So that it's going to be reversionary back to, temporarily, the trust res will go back to the settlor. Constructive trustee was formed, or you might want to say a resulting trust was formed, for the benefit until a new successor or new trustee could be appointed. B, when resignation becomes effective, 152. Even if the trust instrument permits the trustee to resign, the resignation usually is not effective until a successor is appointed. Until a successor is appointed. So once they accept and they decide, well, they don't want the job anymore, I'm afraid you're stuck with it, and we're talking about an irrevocable trust. But what irrevocable means is the trustee can't revoke his trusteeship. Irrevocable trust means the trustee cannot revoke his trusteeship once he's accepted. For a place here. Right, I wanted to mark something here. So the common law notion of a no gap in succession and the interest of sound, secured administration requires that the legal title and duties remain in the trustee until taken on by another. The trustee assumed this obligation in accepting the appointment initially. In other words, he can't wiggle out of it until somebody else is going to step in and take over his duties, and he's still liable. So F, removal of trustee, Section 153. Unless the settlor reserves the power to remove a trustee or confers the power on someone named or described beneficiaries or other persons, only a court of competent jurisdiction may remove a trustee. One on grounds for removal, Section 154. Numerous grounds for removal are recognized, but the basic criterion is whether the trustee's continuance in office would be detrimental to the interest of the beneficiaries. Among the various grounds recognized are legal or practical disability, serious or repeated breach of the trust responsibilities, including the duty to cooperate with co-trustees, and the duty to render accountings or reports. That's important. The first thing to do is to come up with a debt validation request and send it in under, say, 9-210A4, a statement of accounting, because under a notary presentment. And once that's done, since everything we're doing business with today in commerce is really a trust, and we're going to treat it as trust, once we ask for a statement of accounting, this would be grounds for removal and a breach of trust if you do not get a statement. So A, insolvency on page 40, section 155. Insolvency of trustee is generally not in itself a sufficient grounds for removal unless the court finds that the trustee's insolvency jeopardizes the welfare of the trust. Sounds like what they're doing to us today, really. If they're treating all the beneficiaries bankrupt and they construe them all to be trustees, then they're looking at it as being incompetent, and then the trust welfare is really being jeopardized due to the insolvency. So B, animosity, 156. Disagreement or tension between the trustee and one or more of the beneficiaries is not a ground for removal unless the animosity jeopardizes the sound administration of the trust. C, settled appointed trustee. Generally, the courts are less inclined to remove a trustee named by the settler than one appointed by the court. This is particularly true if the alleged grounds for removal, example, conflict of interest, was known to or anticipated by the settler. And now to removal by beneficiaries, 158. If under the trust terms the beneficiaries have the power to modify the trust or to terminate it and compel the trustee to transfer the property to them, they have a power to remove the trustee directly, because it would be pointless to require them to change the terms of the trust or terminate it and immediately create a new trust upon the same terms with a new trustee. That's pretty powerful there. So now, sufficient grounds for removal, legal or practical disability, and then the section insufficient grounds for removal would be insolvency unless welfare of a trust is jeopardized. Sufficient grounds for removal would be serious for repeated breach of trust responsibilities. In other words, you sent out debt validation a couple times and they didn't go after it. They didn't give you what you wanted. Example of failure to render the accounting. So now insufficient grounds for removal, animosity between trustee and beneficiaries unless welfare of trust is jeopardized. Now, sufficient grounds for removal again, refusal to give a bond, and also commission of a crime involving dishonesty, absconding with trust funds, commingling my special deposit. Next one, conflict of interest not contemplated by the settler. Top of page 41. Section G. Merger of title. Merger of title where sole trustee is also sole beneficiary, section 159, where the trustee, the holder of the legal title, and the beneficiary, the holder of full equitable title or beneficial interest, are or become one and the same person. The legal and equitable titles merge, defeating the trust and creating a fee simple absolute in the trustee beneficiary, who thus holds outright and fee free from trust. So free, you need to look that word up. There's nothing free today except for the offer for the obligation. So the merger of the title, anytime when one of the entities has both titles, the titles are perfected, and we have a pre-1933 title, a perfect title. We have a allodial title. But you see, we can't have any allodial titles or perfect titles anymore because we don't have any money, because the trust came in and rushed in and split the titles. And as long as the titles are split, there will be no perfect title, no allodial title. Never can be until you get some money back again. It just looks like you got a perfect title. It's colorable. Until you get lawful money back, until you crack the trust, so to speak, or terminate the trust, and you merge the two titles of the Republic and the public back together again, and then you bring America back, and then you have lawful money again, then you will have perfect title or allodial title. Because you can't have it because it's being held in trust. So the trust purposes have to be fulfilled to terminate the trust. And when you terminate the trust, America will rush back. Number two, the non-identical interest, 161. Where the interests are non-identical, let's skip a section. Let's back up one. Repeat that one again if we didn't. And number one, attempting to decline trusteeship, section 160. If the sole trustee is the sole beneficiary at the outset, it may be argued that the title merges immediately and no trust exists. Therefore, it has been said the trustee beneficiary cannot decline the trusteeship and preserve the trust. But the third restatement position is contrary to this. The restatement of the third, section 69, comment D. Number two, at non-identical interest, 161. Where the interests are non-identical, as where the trustee does not hold exactly the same quantum of interest, legal and equitable, there is no merger, and thus arises frequently where there are multiple trustees who are also beneficiaries. As a general rule, the existence either of multiple trustees or of multiple beneficiaries, or both, precludes a merger. And they go through some examples there. I don't think I'll go through the examples. I'm going to skip those three. I'm going to jump to the next page. Page 42. There's a graph in determining when the legal and equitable titles merge as examples. I don't know if we should go over that or not. There are some examples of some wording there, like it gives examples S to A and trust for A. And S stands for settler. I'm going to continue on, move to page 43. A, where no merger where several trustees are also the beneficiary, section 162. Quote, settler to son and daughter upon trust for son and daughter, unquote, creates a valid trust. No merger. Then there's a case there. It says the settler probably intended son and daughter to jointly manage the equitable interest of each, that is, each co-trustee to hold for the benefit of both. And again, some authorities have disagreed, arguing that there should be a merger in this situation, the quantum and the nature of the estate being identical. And let's see, probably the question is better viewed not as a technical one of merger, but as a question of attempted termination by consent of all beneficiaries. Example, under the Claflin doctrine, if it is applicable to in the jurisdiction, see infra section 954. B, note, some statutes now confirm that the intended declarations of revocable trusts are not defeated by merger. And see the comment, controversy whether a merger has taken place arises most frequently when a creditor is pursuing the beneficiary's assets. The creditor will argue for merger so that she can satisfy her claim out of the beneficiary's legal share of the estate, which is usually more practical and effective than attempting to levy on a beneficiary's equitable interest. And that is exactly what they're doing today. China and other creditors are foreclosing and want their money. The creditors are pursuing the beneficiary's assets, just like it says here. And the creditor will argue for the merger so that they can satisfy their claim out of the beneficiary's legal share of the estate, which is usually more practical and effective than attempting to levy or put a lien on the beneficiary's equitable interests. So today, they are really doing a modern view of construment and effectively starting to tear down the protective walls of the protective trust, discretionary trust, in 1933 that was formed for the protection of the assets of the beneficiaries from the creditors getting at it, because the beneficiaries stopped paying their debts, even though they had the assets. They stopped paying their debts because basically they went to sleep. They didn't know they could. You still can. Section 3, beneficiaries, we'll pick up with that next time on page 43. So let's open it up for some questions.
All right. Folks, if you got a question for Christian, I go ahead and hit *6 on your phone. And as soon as I see it come up here, I'll go ahead and unmute you. And you can go ahead and ask Christian your question. Our first caller is D. Michaels. Go ahead, you've been unmuted.
Hey, Christian, how you doing?
Good. You?
Good, good. I had a question, and especially yesterday, where I completed a notarial protest against one of these mortgage lenders. Now, the unique thing, because I had to find out where they were particularly incorporated out of, and on the filling out the UCC-1, there was an addendum, and I'm trying to find it real quick if I can. There was an addendum that came up that had some very unique wording in it. Was in regards to trustee, if it was, especially where if it was related to property. And I'm trying to find it exactly right here. I wish I would have had it. I didn't realize I'd be the first caller. Oh, here it is. Here it is, right here. Give me 1 second, and it'll pop right up. Okay. In theory. Now, hold on. Here it is, right? It talks about, well, actually, it's actually on the UCC-1. It's the only one that I've seen on the UCC, because a lot of them are different from state to state. But it goes here in saying, it says, note, if debtor is a trust or a trustee acting with respect to property held in trust, enter the debtor's name in item 1 and attach an addendum, which was a UCC 1AD. In other words, and that's something that you would do, like if you were going after in a foreclosure where you know it was procured by fraud and basically they obtained an illegal seizure of a homestead property, is that, and you want to basically turn the tables and satisfy your administrative remedies by doing a notarial protest and actually filing a public notice of a private declaratory judgment by default, because that's basically what they do in a notarial protest. And then you would file that as a UCC-1. Is that correct?
Yeah, I would file that on the one as a notice of that, yeah, to make it public notice of that judgment, yeah. And then a notice.
Right now, that would be, And that would be a notice of interest, not a statement of interest. A statement of interest you would do is where you're basically expressing the trust of what you've done as far as with the. Okay.
Actually, it's both. It's both a notice of interest and a statement of interest, because the certificate is the material fact under the notary's hand and seal, creating the evidence that is outside the hearsay rule. So he's creating a record, but he's also creating a confirmation of the notice of interest, which is, you're using as a notice. So it kind of works both ways in that particular case.
I try to send you a copy of it, but your mailbox is always full. I just wanted to try to get you to look at that actually before I sent it, but I think I did enough homework to be sure that I did it correctly. And then once that's filed, this way, if I want to move further, like filing an ex parte summary judgment against them, which it seems like I have filed so much in this case, and they're just not even putting any of the orders in, so it looks like I'm going to have to file a writ of mandamus to the appellate court saying, hey, at least file these orders timely. Every pleading has gone in with an unsigned order, and you're just sitting on your hands with it. So I'm hoping going to the appellate court will help.
Let's see. Let's back up a little bit. Was that block 15, or I think it is on the addendum, where it talks about trust and trustee there right next to 2 blocks?
Well, this was for a New York UCC. It wasn't on a Florida one. It was on a New York. It was on the UCC one that, and there's only 2 pages. It's on the second page at the bottom. It says, if the debtor is a trust or a trustee acting with respect to property held in trust, then enter the debtor's name in item 1. And I did the addendum.
Right.
Because I had to put a physical description of the property.
Right.
Okay, if that makes sense.
There, whether it's one trust or the trustee, one of the 2.
Right. So I just, and I just wanted to kind of throw it your way, but of course, most of the stuff I send you, it gets kicked back because I figure your mailbox is full.
When I read that was the first thing that caught my eye.
Yeah, and, I went to a few people, and they all said the same thing. That's a Christian question.
My comment would say, where are you putting that evidence at? That certificate?
You mean the UCC one when I get it back?
Well, the UCC when you get it back is going to go really with your whole package, and the county notice is going to go with your whole package. So that whole package, that certificate, that judgment already on a private administrative side, it's key where that goes. Because if that goes back into the public side of the court, you just stubbed yourself in the foot, or worse yet.
No, nothing's gone in there yet at all. Nothing at all, because the thing was, when I was... Is
this an open case?
Sorry?
Is this an open case, ongoing case?
Well, yeah, this was a foreclosure that happened about 5 years ago. What we're going back under petition to vacate a void judgment based on newly discovered evidence, which was found that they filed a lost note affidavit. And I'm still waiting to get that copy because they have denied discovery the whole way through it, which is I've done a challenge to jurisdiction. I've done a petition to vacate a void judgment. I've done a petition for discovery, amended petition for discovery, petition to compel. I did a petition to...
all that stuff is colorable on the public side. What are you doing on the private side?
Basically, they're defaulted under a notarial protest where I did an official demand and notice to respond twice. And then the third time...
evidence. What are you doing with the evidence?
The evidence I still have everything.
Well, it isn't doing any good in your hands. So do they have copies of it, and is it in the right place in the private side of the court?
Well, that's what I did.
I put it into the judge's chamber.
Well, that's what I did, and when I asked for to basically to bring it in chambers in camera, he denied my request.
Do you have a protective order on it? Do you have a protective order on it?
I'm not sure what you mean by protective order.
Protective order establishes CCI information or trade secret information, and that gives you the right to have an in-camera hearing. No protective order, no hearing. There's no need for a in-camera hearing without secret information. What establishes secret information is the protective order.
But are we getting it from that? Am I to get it from that same court?
Yeah, well, yeah. At least you got to put a motion in there for a protective order. If you don't get it, now you got grounds that they're denying you due process because they won't allow you to put your information in the court to defend yourself.
Okay, I missed that. I missed that as far as the protective order.
Yeah, protective order is important because protective order actually establishes your trade secret information as trade secret information or state evidence, state secrets.
Okay. Yeah. Okay. Because I think everything is very complete as far as what I've done, but the notarial protest was not. It was actually just sent to the judge in private, in a private notice. It wasn't entered
with
into
no
the record.
protective order on it. He can't see that it's secret, so he's going to treat it like everything else and say, okay, well, I don't see a reason to have a hearing here because I don't see any secret information. You didn't establish
so it has
fact that your material facts are secret information.
Okay, so that's the next thing is like a petition for protective order.
Yes. And if they deny that, well, they just gave you a win.
Oh, I think they've given me a win anyway. I mean, just by their acquiescence. I mean, they're not responding at all. I hit them from every side.
Right. Bring in your certificates that proves that you won by notary estoppel, res judicata, and they're not treating it as the rights of a substantive man. And as soon as you bring it into the public side of the court, then you waive it. And they got you.
What?
You waive it. So they're trying to. Yeah, we're not doing the right steps to bring it in properly and get it into chambers so you can get it looked at, because the judge is trying to keep it out because, once it gets in there, then he's got to rule on it without the robe on. He's not in an administrative court. Now he's a judge. And equity,
That's
in
right.
the eyes of consciousness of equity, is in chambers. But that's where you want to be, and I need my evidence in there for him to rule on that. So somehow I got to get that evidence in there. But if you put a protective order on there, motion in there, and they deny your motion for protective order, but you got to go back to federal. The best thing to do is get O'Connor's Federal Rules Civil Trials.
I have okay, O'Connor.
Yeah, Federal Rules Civil Trials. It's O'Connor's. OCONNORS. O'Connor's. In there, they give you a digital CD also with it that gives you all the documentation to set up all kinds of motions under federal. And one of the guidelines you want to use is you want to use the protective order example that they've got in there, because in that book and through those documents, it'll explain to you every necessary element that you have to have qualified for a protective order.
Okay. But the thing is, the thing is even in the courts of equity, under the Florida Rules of Civil Procedure, even under 1.500 and 1.540 of setting aside a void judgment, he still has the authority to rule on that, and he's just sat on his hands.
Yeah, because they're going to tie you up.
They're going to try.
You're not giving the judge what he needs to rule in your favor. You got to get your evidence in there, and in order to get your evidence in there, you got to have a protective order, and the protective order has to have the necessary elements to establish that you got trade secret information, that you got CCI information. Then they can't deny you the protective order, because if they did deny you the protective order, you just got to win. But you got to make sure that you got the criteria to set the protective order, the necessary elements under it, that they're all there, that they can't get you on some little technicality because, oops, I missed one of the elements.
Okay. Elements or trade secrets?
Well, no, elements of the protective order.
Oh, okay. I thought you said elements for trade secrets.
Yeah, the elements to set up the protective order that establishes that you got trade secret information.
Okay. Set up. Protective order.
You know, they got these courts set up with all these little twisty turns and these little things and all the stuff you got to do, and really we haven't studied the courts long enough to figure out, you know, what are all the right moves, and if we leave one out, then they nail us with it.
That's what they want to do. They just want to nail us on a technicality.
Yeah, they make it very hard for us to get a remedy, but a remedy still is attainable, you know. All I got to do is get my chess piece in chambers somehow to prove with my material facts the claim. And once I got my evidence in there, you're pretty much home free.
Yeah, but it's also, you know, it's okay that there was a delay because I've already sent my notice of interest to the UCC on the trust. So once that gets established and I have a record as a registered number, which I basically created my number, then that's filed with the state. That means I can go turn around and file it in the county, which I think under the UCC 1 form, it's under fixtures or fixing fixtures, which means filing it in the county. Once it gets filed in the county, then there's a public notice of my grantor beneficiary status.
Yeah, that's your SOIs. Your UCC and the counties, the SOIs.
Right. Yeah. So I'm still waiting for that to come back. So maybe it's okay. It might have been maybe a little stumble, but once I have that back and it's registered with the state, then I can go back into the county and then back into that case and saying, well, here it is.
Yeah. What is your trust in this case?
I'm sorry?
The SOIs that you're creating, what is it for? What is the trust?
Well, that's like you've been saying, is that has to be established, and that was when redoing with the SS5 and coming in under grantor with the SS5, and then once you got the card back, now you come in as beneficiary with the SS card. So this way you separate more or less your living man from that Cestacute trust. Okay,
but this is a case involving a mortgage foreclosure, right?
Yeah. Well, really, what I'm hitting them on discovery. They've never provided discovery.
Okay, but what is the primary thing we're doing here, though?
Well, the big thing is that they're just not responding to anything. And the one thing is, even on the discovery, there's still, once again, there's an inalienable right, because you're claiming under the 4th and 5th Amendment of the U.S. Constitution, also the Florida Constitution, which is under unlawful.
I heard one word that you need to say, and the one word you need to say is trust. Where's your trust?
I guess I'm not understanding your question. What do you mean, where's my trust?
You haven't established it yet, Christian.
Yeah, that's what I'm thinking. Yeah, I'm thinking that you really haven't established the trust.
You got to go back to the mortgage application.
No, but isn't the establishment with the UCC 1?
Let's now, we're talking about a mortgage case with, and then we're confusing that with this Social Security account. Now, this case is another subtrust that is trying to gain access into that Social Security account. So if they win in this case, then they're going to have the right to go in and access that account. But I really don't have to do anything with the Social Security account. I have to handle this immediate case because that's the trust that's on the plate right now. Where's the first signature on that case? That's the trust. Is the case been established? Trust, res, property?
Yeah, you mean the mortgage deed, the promissory note. Is that what you're referring to?
Well, that could be the colorable res, so to speak, but, where is that? Where is that at? That's in the case. So your current
actually,
case
it's not on the
that's the trust. I want to turn that case, which is going to encompass everything in that case and everything proceeding from that case, all the bonds and everything in the background. That's going to be trust res. I'm going to turn that case into trust res property. That's going to be my trust. It ain't got nothing to do with Social Security account. I don't have to prove that, just nothing. I need to prove the trust, the current trust that's on my plate. The case is the current trust, res. I'm going to turn the case into trust res, and that's what I need the UCC-1 and the county for, to claim it. And then I'm going to do a 3 and a county to prove that I transferred that trust res into some trustee. So do you have the documentation to prove that your case is a trust, and do you have the documentation that once you turned it into trust res that it was transferred to a trustee? And that was your intent and purpose?
The only thing that I have, and that has been, and the only reason I have it is because it's public information, is the original mortgage deed, which was the promissory note. That's the only thing that is there. Even after filing, like I said, the petition for discovery, amended petition, compelled for discovery, nothing. They are not doing anything.
Don't you have a case going on open that you?
Yeah. There's a case. Right. There's a case.
Okay. Then, your note is in that case, right?
No, because they filed a lost note affidavit. There is no note. They sold it.
Well, I thought you said you had the note.
No, well, I have a copy of the mortgage deed, which was owned by, it was called Ford Financial or something like that, and then it was bought out by Citigroup, or City Financial Mortgage, which was FKA, formerly known as. And basically, they have filed a lost note affidavit.
On the first one that you're claiming that it's going to be a trust, what is in your collateral block that you're claiming?
Let me see. 1 second. The collateral block.
In other words, you have the case number, say, being the trust res in that collateral block.
Is that under the? Now we're talking Social Security now, right? The one.
Oh no, you're
in regards to
Social Security is a different trust. We got multiple trusts here we're working with.
Right, but you're saying the first thing that we have to establish is our public notice of grantor and beneficiary status.
Okay, I mean, we use that on a sideline to establish that going along. Your immediate need is your case that you're working on right now, which is the case that you're turning into a trust and going to do a special deposit with.
Right, no, I haven't done the UCC-1 on that yet.
You don't have a trust.
Okay, so I have to establish the UCC-1 on that.
Yeah, your case that you're suing them in with the counterclaim is the trust. I'm going to turn that into trust res and put that on a UCC-1, that case number, and all proceeds therefrom.
Does it matter if you're the plaintiff or the
No, if he's plaintiff or defendant, any difference, no.
That doesn't matter. You still claim trust.
Yeah.
So with a mortgage, Christian, you taught me that the 1003 is your proof, and then you create 2 witnesses. What is it for a case? Because you didn't sign anything there. Did you?
Yeah, you did. You didn't know it. Who's holding the case?
Is it the court?
Yeah.
The courthouse. That thing's bonded.
Is it
right.
a complaint that you
Who is the grantor on that case?
Well, whoever signed.
Didn't you sign it? Didn't you sign your petition?
Okay, so that's what it is. So you need to make a copy of your petition, put the case
when you
on it.
filed the case on your petition, did you sign it by grantor?
I got it.
No.
Now, do you do the same
No?
thing, Christian, where you
Why not? What is the rule of signatures, guys?
qualified
First rule of
endorsement?
signatures in expressing the trust.
Qualified endorsement
No,
by grantor.
Yeah, I keep on hammering it home. You got to pay particular attention, especially when you're signing your name, because when you sign your name to any document, you are forming a trust.
What about UCC 3-115?
Yeah, that'd be an incomplete instrument, an offer that came in your mailbox, or some offer that they came and charged you with a court charge with, or indictment.
No, but I'm talking about when the case was originally opened. Of course, probably nobody.
That's
signed
another trust.
any-
That is another trust.
Like when the case was originally, but I mean,
Look,
from
there is
this point out, like,
multiple trusts. Wasn't there another signature on that case?
well,
Usually,
one minus the.
other signature, if it's not directing out of that one, say that petition, everything follows up, all those follow motions that you keep on signing, they come by the first one to set it up was the petition. So everything following from the petition is the same trust in that instance. But this other case that you got with the first one that happened 5 years previous to that, that is another trust.
Okay, but everything that I'm fighting in that case from 5 years, everything that's been recently filed has been signed by grantor.
Yeah, you're encompassing that old case and putting it into this new case and taking all of that over as trust res.
It's the same case.
Well, you're making it into your case. And you're incorporating it into your trust. So that trust is going to be incorporated into your trust. And then you're going to turn all of that into a trust res and all the proceeds hanging on the background with it. And you're going to do a special deposit on that after you have claimed that you got the trust, the title, on a UCC-1.
Now, is there anything on like the Free Americans that kind of gives us like an example of how a UCC-1 should be properly filled out in showing this and illustrating this?
You know, I don't think that actually it's the UCC-1 that's going to enlighten you. It's really the basic understanding that, hey, this is what we're talking about being a trust. Really, it comes back to the basic elements: intent, purpose, party, specific, trust, res. And one of the methods of formation, and looking at it, that anything that I'm signing my name to at that moment, I better wake up and say, hey, what kind of a relationship are we forming here? If this is not a trust, I'm going to turn it into a trust. And I know how to turn it into a trust because I got the basics down. I don't need to know anything about a UCC. I don't have to even look at a UCC because that's something different. That's just establishing a record of a material fact that I'm going to prove the case with.
Right, exactly, and that's what the judge is going to go by.
Yeah, but he's going to go by by that time, I either won or lost by what I did prior to that. If I didn't set up the thing right to begin with, I'm not going to be able to prove the trust. And my UCC 103 got the elements and the method on it, then I'm dead.
Well, at least in that court. But you remember, it's always an appealable condition. You could still take that. Because, you know, mostly, especially... I'm sorry, you cut out.
You're talking about litigation. I'm talking about trust. I'm playing in a whole different realm, you guys. And I can tell by the questions that you ask, you don't know what's going on yet.
Well, it's because we're so used to thinking equity, thinking statutes, thinking laws, case law. That's how we've been.
I know. You know, but believe me, I've trained myself. I know where you're at. So.
You know, and that's what I do because I hammer them really good on that end, which they understand. And once you start bringing it,
most everybody, including you, do not understand the basics about trust.
Well, it's a new process. That's all. It's a new process. It's not impossible to learn, but it's just
doing that to be derogatory. I'm just saying that we need to go back to the basics and really hammer home the basics, because we're going to lose or win on the basics. And I understand most people have an immediate problem they got to fix, or they got something going on, but we got to get these basics down. That's why I keep on going over the same stuff here. This is the second time I've gone over this same section. It's a different way of looking, and I have to open other people's eyes to see what I see. And I think people are starting to see that, but it's like we got to keep repeating and repeating and repeating.
It's a process, and it's so new to everybody. That's the thing.
Yeah,
it's so new.
I know. But it's the first signature. That's why I say we got to establish, what we're doing when we're signing, because that's when you're forming the trust. So I want to come back.
But it's just like learning a new language. It's like when you start learning a new language, it is so difficult, and there has to be so much repetition before it starts jiving, because the only thing you really know is no habla.
Yeah, right.
And it's repetition. With me, it's repetition. I wish I had a photogenic memory, which I don't, but, I just got to keep, I do understand some of the basics, but it's a whole new language.
Yeah. Well, you see where you messed up? You should have been talking about trust, which would be in the immediate case that you've just formed. And at that petition, that is the case that's going to encompass everything else that you want, and that's going to be incorporated into that case. And all the invisible stuff that you didn't see, all the bonds that they attached in the background that are running for them, you're going to encompass them also. So in effect, you're just taking it all in one swoop. You're consolidating all down into your case, your trust.
Yeah, but the thing is, I'm still not out of the woods, because I'm still hammering them on their side of what the things that they know, especially on the equity side, the case law side, and everything.
What you're doing is you're traversing into the case, and you're falling into their trap. Well, you're arguing their material facts. No, I want to establish mine and get them to argue my material facts, not argue their material facts.
Right, but even I understand what you're saying, and I agree, and that's kind of like the big ace in the hole, like you said, the 600-pound gorilla. But yet again, too, even on their side, I still have good grounds, because of, I believe they just even on the regular, the not real party of interest, holder in due course, blah 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 blah.
Right.
Same thing
I'm not
there.
talking about getting a case. I'm here to teach about trust.
I understand.
We're using trust as an offense method of, going on the attack, and which is completely different from everybody what they were using as a defense for asset protection. Because what I see here is the 900-pound gorilla. I got to get you guys up to the point to where you can release that 900-pound gorilla, and that 900-pound gorilla is only a 900-pound gorilla in chambers.
Okay.
And you want to tell me all about your litigation stuff on the public side, which to me means nothing really, because that's not where the 900-pound gorilla is at. I'm going to bring you over to where the 900-pound gorilla is, on the other side, in chambers. How do we get there?
Right. No, I understand what you're saying. Like I said, it's just a new language, and sometimes it takes a little time to understand it. But once it's kind of like the Japanese. Once they learn how to do it, then it's like it's like get out of the way.
Right. It takes a little time, yeah.
Okay. Well, that was really my only question, and hopefully I'll send you some stuff that your mailbox will be empty at a time.
Or try one of my other mailboxes now. I got umpteen of them now.
Oh, wow. Well, I only know the moving titles one.
Okay. All right.
Rhonda Ray, you out there?
Yeah.
You got a question? Go ahead. You're next.
Hi, Christian.
Hi, Rhonda. How you doing?
My 900-pound gorilla is about to bust loose.
Great.
I think I understand the basics pretty good. If I could recommend, go back and listen to a lot of the audios over the last 2-3 months. And get that you want the repetition, there you can get it. And it's really been beneficial to me the last 2 or 3 months, listening to all those audios. And
anyone in particular?
All of them. I've listened to all of them. There is some. You are going to hear things over again, but that's okay. That's how you learn. Repetition. And driving it in your head. And not all of us are at the basic ground level, I don't think. And because some of us have put a couple, 2-3 months into it already. And so just keep studying and learning. I'm just, my gorilla's getting hard to handle. He's wanting to not be bullied around too much anymore.
Okay, great.
So looking forward to that. That's all I had to say. Thank you. Have a good night.
Okay, thanks, Rhonda.
Hey, folks, if you got a question for Christian, go ahead and hit *6 on your phone. And I'll see it pop up on my screen. I'll go ahead and unmute you, give you an opportunity to talk with Christian, ask a question. While we're waiting here, Christian, I do have a question for you regarding some previous discussions with declaring the trust NOI and then proving the trust with your 2 witnesses. You had mentioned using a unique number and then putting that on your notice to the county and then the UCC one for the state, and then pulling out certified copies. My question for you is regarding the multiple documents that you had mentioned that would be included in that. So, you'd have a real generic notice that you would declare based on that number, that unique number. But then you had mentioned that there were several documents that you would hold in the private. And I'm assuming that all of those would all have that same unique number written down on the footnotes?
Yeah, I would put all the documentation to be in the footnotes, the same number. That way, all but like in one, tied up in one package.
Now, if I understand correctly, that particular number for that particular trust, those documents that you'd be including in that would be all supporting that particular trust. Is that correct?
Yes, right.
So the SS5 trust, you would only have documents specifically for that. You would not have trust or mortgage documents with that unique number on it. You would keep that for the mortgage trust. So you separate them out that way.
Separate unique number, yeah.
And then same for any court case.
Correct, yeah.
Great. Thank you. That was my my question, just to make sure I understood that. And the nice thing is once you establish that through your SOI, you don't have to continue to file paperwork into the public. All you have to do is just keep adding that to, let's say, your file with that unique number on the bottom of the page.
Yeah, keep that number on and adding to it, and you're done. You don't have to file every new document comes in because it's incorporated by that number, referenced by that number, incorporated herein by that reference number.
And that's your TCI, is that correct? Your trade secret information?
That's TCI, yeah. Mm-hmm.
Okay. And
because they don't want you to look at that as being a trust that you're taking and grabbing the whole thing. That would be too much shock for the public. And they have to say, well, we got to protect that information from coming in here because that is state secret information. State secret information was Black's Law. Black's Law, state secret.
The actual term is state secret?
Yeah, state secret. A governmental matter that would be threat to the national defense or diplomatic interest of the United States if revealed. Now, why would it be diplomatic interest? Reading on. Information possessed by the government or of a military or diplomatic nature again, where the disclosure of which would be contrary to the public interests. CCI information.
That Black's 8th?
Secret information. Black's Law, state secret, yes, 8th edition.
That was 8th. The 7th is a little different, a governmental matter that would be a threat to the national defense or diplomatic interests of the United States if revealed, and is therefore protected against disclosure by a witness in an ordinary judicial proceeding.
Now, why is it diplomatic? Because we, the people, are foreign to the jurisdiction of the United States. We are different entities.
So they set up this...
All falls under diplomacy.
They decided to use... Okay, yep, diplomacy. And they decided to use this form, this trust...
to hide America.
Yeah, exactly. And that's why they call it state secret. And that's why you keep pounding away at us. We cannot come into court and declare this.
Right, you waive it.
You waive it. And you waive it.
For 90.506 of Florida Rules of Evidence and 90.507 is the waiver. By voluntary disclosure. We come into court and put that on the public side of the court. We voluntarily disclose that, and they don't want to have that in this because they know it's trade secret. They know it's state secret stuff. They know you're foreign. They can't have you shocking those people that aren't awake again.
Yeah.
They got to keep it quiet.
So what's the sequence, Christian, as far as a court case is concerned? Do you put the do you package that information up and send it to the judge in his chambers, and with the motion included with that package for the protective order together, or do you do the protective order?
No, the motion goes on the public side because you got to instruct the public side of the court what to do. So the motion on the public side instructs the court, hey, you got to have a protective order. There's my protective order motion in there. And then there's the notice of the hearing on the public side, so that you can tell the court there's got to be a hearing, and it's got to be an in-chamber hearing, and da-da-da, and on and on and on.
And
so the
then you provide the information.
Goes on the public side, but the actual, so that's acting as the NOI on the public side, but then the SOIs have got to go into chambers, because that's the CCI.
Okay, so you're basically setting up your structure with your NOI. Hey, I need a motion for an in-camera hearing. I need a motion for a protective order, all done on the public side, and then you are protected then to bring in that TCI information into chambers.
Yes, and if I've had the right elements under my protective order, the judges see, I can see we need a protective order onto this. He'll grant the order, and he'll grant the hearing because you got CCI.
When you say, you're saying T is in Tango, C is in Charlie. Is that correct? TCI?
No, C. Cat, I.
It is CCI.
Confidential, commercial information.
Okay, that was the word, confidential. Which is different than TCI, trade, or what is it? Okay, CCI.
Trade, at TS.
Yeah, TSI, trade secret information, and CCI, confidential commercial information.
Yes, let me read you out of the federal rules of state court here in Florida under 1.280, which is discovery, and under C7, which is protective orders. C is protective orders. So that's 1.280. That's general provisions governing discovery. Subsection C is protective orders. And in particular, it says, I have some marked ones here. Number 2, so C2 is that a discovery may be had only on specified terms and conditions, including the designation of the time of the place. And I'm jumping down to C5, that discovery be conducted with no one present except persons designated by the court. And C7 then is that trade secret or other confidential research, development, or commercial information. There's your confidential commercial information not be disclosed or be disclosed only in a designated way. There's my CCR, my trade secret information, and that's what is state secret, because it's all diplomatic and it's only revealable in chambers, or else you're going to waive it under 90.507 by voluntarily disclosing it on the public side. Get your state rules of evidence comporting to Rule 501 and federal. See what your state rules say under
501.
Yeah, 501 federal. 501 federal just basically says we go to your local state rules. So you got to go to your state rules. 501 just says go to the state rules. Go to your state rules and find out what is, how it comports to Florida here under, 501 breaks down to 90.501 through 510. So they break it down into 10 subsections. But in particular, 90.506 and 90.507 in Florida states 506 is privilege with respect to trade secrets, and 507 is waiver of the privilege by voluntary disclosure. But you got to find out what it says in your state, because you're going by your state rules.
And that's different from the Florida 1.280C7?
Yeah, it's going to be different, and it's maybe a little bit in its wording, but its meaning is probably going to be there. All states comport to, basically the same stuff.
Oh, okay. So 1.280C7 is protective order information, and 90.506 and 507 is
under Florida.
But I mean, that particular section discusses
501 is federal.
Revealing it and waiving it.
507 is Florida.
Oh, okay.
I'm looking at a book called Florida and Federal Evidence Rules with Commentary. Now, they make one for New York, and they make one for Texas. If you happen to be in one of those states, get that book. But I would get that book anyway, because it's going to explain to you a lot of stuff. You just got to cross-reference it. I mean, we went through a show once before on this. I mean, you read this stuff, and you're going to find out that everything you've been doing in court's been all wrong. Been putting in evidence and waiving it. And you never knew it. And then we come and we complain about the judges. They're so corrupt. We just don't know the process and procedures that they're operating on, and it's strictly foreign to us. It doesn't comport to common law at all. It's strictly summary judgment. Equity and common law, they say, have been combined into one thing called summary judgment, which is another disguise for saying that, okay, we've disguised equity. It now means statutes and codes, and real equity is now in chambers hidden. It's being held in trust.
Yeah. I'm actually young enough. I haven't had to go to do a bunch of things in court, so I don't have to unlearn a bunch of stuff. I can just learn the right thing from the get-go here.
Well, I'll tell you, that's a different realm in court, I'll tell you. It does not operate the way we think. And it really comes down to a lot of us don't understand how to do basic government. I keep coming back to that. We don't understand basic government. And basic government is really, you got due process, which is basic government. Due process, you got to have a hearing. The opposing party has to have a chance to rebut and cross-examine, and you got to be able to bring in your evidence. No evidence, you got conclusory pleading that's unsubstantiated, can't corroborate it, and bingo, you're dead. Well, that stinking judge, he didn't allow me to do this, didn't allow me to do that. Well, I'm sorry, they got rules that you got to comport to get your evidence in there in a particular way, because you got to make this left turn, go down 2 blocks, and make another right turn, go 6 miles, and then turn left at the telephone pole. If you don't do that, you don't win. But we all of us come in there and say, oh, I don't want to make that long run like that. I can't do that. No, you got to. You got to if you want to win. So anyway, it's really our own basic ignorance. And believe me, I'm coming from that myself. So I don't mean to be derogatory on anybody, but don't take it the wrong way. We're our own worst enemies. I think if we do the procedures and the forms and the process right, you got them in a rock and a hard spot that they got to perform the duty. Now it comes down to whether or not this judge wants to be a rogue judge or does he want to be a judge. And equity is where the conscience of the court is. That's where the 900-pound gorilla is. And it's all about trust. Trust is equity. Equity is trust. So another question?
Not right now, Christian. I think that back, Rhonda Ray did have, she hit star 6. Are you out there, Rhonda? Can you hear us?
Yeah.
I think you had another comment you wanted to make?
Yeah, I was just going to clarify on if you're dealing with a case, you put the RA number on the case when earlier you was talking about claiming that case as a trust, making that case into a trust, and claiming that case number. Could you also do that by putting an RA number on that case? And
I could say somewhere in the documentation of that case that this case number such and such, also known as RA such and such and such,
Okay, just so it, and then
connect two together.
When you identify it when you claim it all on the UCC one, that's how you're going to claim it by the RA number instead of the case number then.
Yeah, because that's more private yet.
Right. Okay, that was my question. Thank you.
And you also mentioned, Christian, to slap it on an envelope and mail it to yourself, so it's documented and registered.
Get a number from the post office and start using it. No, you got to cancel it by sending yourself that envelope. And don't just put nothing in the envelope. Put a piece of paper in there and send it to yourself, because they question that. If you send something in there with nothing in it, I did that one time, and I didn't even seal the thing. I said, here, stick it on there and send it, and they complained. He said, you got to put something in there and you got to seal it.
See, it's those little things back on those recordings that you go over, because it's all those little things that, tear down our side of it. And just knowing to cancel that RA number so that you own it forever and it's yours, and that those are bingos, as you like to call them.
Yeah, but it gets your mind in gear to think what you're doing, because really with the right mentality and thinking, you would have come up with that deduction. How could I claim a number if I just went and got a number and started sticking it on nowhere? It would stand to reason. Well, should I cancel it? And, well, how am I going to cancel it? Well, I'll send it to myself. Or send it to somebody else, But if I got the thing I'm holding on to it, I'm liable for it. I'm the holder. I'm the owner of it, so I'm going to send it to myself.
Well, I appreciate you. First time I heard that was from one of your shows, and I appreciate hearing it from you, because I certainly didn't think of it myself. But like you said, once you hear it and you think about it, it makes perfect sense.
Yeah. Yeah, it's just getting our minds in gear to start thinking a little more. What do I need to prove this case? What is the case? We got to drive it back to the first logical point. We're like constructing a syllogism, and all your elements need to be in the syllogism and before you come to the deduction. It's all strictly logic, which is logos. And logos is where we got logic from, and logos means the Word. So the Word was God. The Word, logic, is God. He has a logical mind. He thinks very logically. He has an ordered mind. The logos, Greek for word, which is where we got logic from. Everything runs in a logical sequence through deduction.
Cause and effect.
Kind of, yeah, but you can't get an effect without, the facts being in the cause.
Although miracles can transcend cause and effect.
Again?
I say miracles can transcend cause and effect.
Purpose of signs and wonders. Yeah.
We got another caller here, Christian from California, with a question. If you can hear us, go ahead. You've been unmuted from California.
Hi, Christian. This is Carlos.
Hi, Carlos. How are you doing?
Good. Talking about foreclosures, a little question here. Yes, to add a little more protection to our, once we express the trust on a property, on our property, for instance, we wanted to add a little more security or insurance to make sure we keep that property forever or as long as we want. Can we put a lien, or what kind of lien would you recommend? Maybe this question is also for Harold, if Harold is present, or you. A PMSI lien, or what kind of AG lien, or what kind of lien is the most powerful lien that you can think of?
Well, actually, a lien is a bond, and if you bond it, you're actually subrogated it, so you own it. Remember we were talking about bonds here, that the trustee needs to be bonded?
Yes.
A bond is a lien.
Okay.
If I can find it quick, we're talking about the bonds here. Okay, that's on page 34, it's section 132, bonding. So you might want to go over that little section there.
Okay, page 34. Okay. I don't have my book in front of me, but it's I'm writing down.
Is that page 132 in the trust book?
Yeah, Gilbert's page 34, yeah, section 132, bonding.
34, okay.
As under 1, it says the court may order a bond to protect beneficiary's interest. Or 2, it says the court may override the waiver of a bond. But anyway, a bonding. So a bond is used in a trust. There was another place that was talking about bonds too, but I forget where that's at.
So once we express the trust, we don't have any risk of the bank coming back and claiming their property, their alleged property.
Well, if you foreclose on them under trust, I don't think they've got any standing to come out and try to come in with a counterclaim under debtor creditor. Because really the trust is higher law form, whether everybody knows it.
Right. So are we actually foreclosing, when we express the trust, are we foreclosing on them?
Yeah, basically that's what you're doing, yeah.
Okay, I got it. And my question was just as a debtor creditor, putting a lien, because I know a lot of guys put a mechanics liens or some other type of liens, PMSI liens, so an AG lien, in case that they lost their case as a debtor creditor, the bank had to pay them for the lien in case the bank wanted to keep that home. Do you get my point?
Uh-huh. And well, the lien actually becomes a trust res, so.
Okay. Going back to the same thing.
Yeah.
All right. Good enough. I'm surprised you don't have any other questions.
I must have scared them all off tonight.
We got they're slowly creeping in here. Massachusetts caller, you've been unmuted. Go ahead with your question.
Hi, hello, Christian.
Hi, how you doing?
I'm doing well. This is Dennis from Massachusetts. Christian, I'm trying to play catch up here still with the information you're giving. There's many trusts out there. There's constructive trust, nominee trust, express trust, irrevocable trust, and so on and so on. But I guess my question is, a trust is the trust. So what we're learning here applies to all those trusts. Is that correct?
Yes. Look at them this way. All statutory trusts are the same, say. No matter what they're called, everything that you just named there.
Okay.
But now, private trust is different because private trust is not statutory.
Right.
So there's either a black trust or a white trust.
All right.
Private
so just
trust, black trust, statutory. I may have many different statutory trusts, which are all really sub-trusts trying to get in off of that main sub-trust one, that Social Security account.
Right. Okay, so the ones we operate in out in the public are mainly statutory trust, and the ones we create for our own are mainly private trust. And that's probably the best way to go for your own individual needs.
Yeah. Right. Right.
Okay. Thank you.
900-pound gorilla is a private trust operating in a court of equity. It's
Next
like
one. Go ahead, Chris.
It's like we had a perfect title running up from this country was formed 1776 up to a point 1933, and all of a sudden the trust end of it did a divergence to the right and took on a parallel path, same way we were going from 1933 and on. But we, the people, kept on going straight, and we didn't realize that we made a separation, and here it's looking different.
Right.
And we made a switch. So when they came along and creating all this evidence as debtor creditor under a construment or a misconstruement of trust, because we didn't express the trust, it was really our fault because we didn't know it was trust. I keep coming back to the point, no party in the trust needs to know or understand they're forming a trust. But it does not negate the fact that a trust is formed if all the necessary elements are there for the trust, and one of the methods of formation, then you got to trust that the law will recognize. Now you got to trust. So you can claim the trust, prove the trust, and now you can come in and act as the grantor or, say, the beneficiary or the trustee, whatever position you want to be in there.
Okay, so when you see language like that, grantor, trustee, beneficiary, settler, whatever it might be, you would not see that in a document or any, oh God help me, type of situation if the trust was not, if a trust was not being created, correct?
Well, a trust is created when I give you my pen and say I want my pen back.
True, that's true, right. You would trust me with
nothing
with
was
your
said
pen.
about trust wording. Nothing was said about my intent and purpose being a trust. In fact, you didn't even know or understand that I was forming a trust.
Right. I guess my question is regarding written documents. When you see those words on a document, then they are used. They are not used for anything else but a trust. Those type of words on a document. That's what.
An example would be your warranty deed into the county, because it firmly says in there that there's a grantor and a grantee on there.
My mortgage, correct.
Yeah, right.
Yeah.
So anything that really has that, explicit wording, then right away you know it's a trust.
Right, and they can deny that.
Technology that is used that really signifies a trust, because if you're talking about interest, that's a trust. If you're talking about use, that's a trust. We got to go back to some of these old terminologies, because it doesn't mean what we think it means anymore. Just like free, there's nothing free today. If you go back to the definition source of free came from freeholder, where we get a fee simple. And actually, what was free was you were presented an obligation, and whether you accepted it or not. So the offer was free, but yet was for an offer for an obligation, because the freeholder was really the duty of the trustee who he owed to the Lord to carry out his will, which was to take care of the property that he's holding in fee simple as the terra tenant on the land for the purpose of the beneficiary. What was free about that?
Right.
It was an obligation. So we're being sidetracked by the wordsmithing of definitions.
Absolutely, that's correct. Yeah, no doubt about that.
They're hypothecating us to pledge our properties into trusts that we don't even know or understand. So what I'm trying to do is waking everybody up that, hey, you can know, you can understand what's going on here, and you can use it to your advantage. I see a 900-pound gorilla. So another question?
Yeah, Christian. Next question. It's non-member. Go ahead. You've been unmuted. Oh, he muted himself again. Can you hear us?
Can you hear me, guys?
Yeah, go ahead.
Hey, Christian, this is Eric in Florida.
Go ahead, Eric. How are you doing?
Hey, question. When I'm doing my notice of dishonor after my notary presentments, can I list 2 previous presentments on one notice of dishonor, and would that be valid?
Don't you have a certificate from the first one?
You mean a notice of fault and opportunity to cure, you mean?
From the notary, right.
Well, I sent out a notice of fault for both of the previous presentments recently, and then now I want to send out one notice of certificate of dishonor non-performance for both of the previous presentments.
Okay, a notary can't do something that he can't certify something that he didn't do.
Right.
Was the notary involved in the first process?
Well, there was 2 different notaries, so I can only do the certificate of dishonor from the notary that I'm working with on this one, and I'll have to go back to the other one. Okay, I understand.
Right.
But if it
now,
was
here's
the same notary,
workaround to that. If it's something that you really need to, the notary won't generate you a certificate or something. What you need to do is make up an affidavit of what was done because it was actually your process. Take that affidavit, go get it jurated, and then go to that notary, any notary, ask him to generate a certificate based on what you say. Now, you are the competent fact witness on which the notary is sworn to, because he's going to swear you in. He's going to do an acknowledgement, and then he's going to generate a certificate based on your evidence that you're presenting to him. So that's the workaround.
Okay. And of course, my questions pertain to mortgage and that arena. And in order to have substance when we go into the court, on the equity side, in order to present ourselves not only as the living man, but also a living man with substance, what if we were to present ourselves with, for example, a silver bond instead of just going in there insolvent?
What's the silver bond for? The silver bond was to shove it into the public side. Now, what do you want to shove a public-sided silver bond into a private-side court?
Okay, so the only substance we need to bring is our living, breathing self.
What is that silver bond based on? Your signature. So my signature in a private is the only thing that is the bond. Anything I put my signature to on the private side is a bond. It's the asset. It's the bond of my word. And what is a promissory note? A bond, a promise.
And the reason that we are successful in the equity side and the private side is because the plaintiff or the attorney for the plaintiff, for example, the bank, they don't come with anybody who is a living, breathing private person. They can only act on the public side of the court because they don't bring any real party of interest. Is that also part of their disadvantage?
Yeah, but the real power of it comes through the trust is equity, because equity is the compelling of a duty that you didn't do, or it's going to compel you not to do a breach. That's the power for the trust. It's equity. It's in the compelling. And also, once you made the prima facie case, the burden of proof for the onus probandi shifts upon the trustee, and he's presumed to be guilty unless he can prove that he has a record of a payment or a disbursement. That's the 2 powers of the trust under equity. That's the 900-pound gorilla.
And by claiming the trust as grantor, we can go ahead and assign roles, and we would assign the trustee away from us in that situation and assign that to, for example, the attorney with the bank. Is that the idea here?
Yes, you could assign yourself beneficiary, but then I would say you got to almost have the master file in the IRS to comport to what you just said. because all other agencies must comport to that IRS record. Now, if you establish yourself in that IRS record by making out a 1040 form, forming a trust by declaration, and you appointed your status to be trustee, and then you come into this case and say that I'm beneficiary, they don't comport. And they're going to look at you to be an incompetent, and they're going to take the trust away and form the discretionary thing, and they're not going to honor it.
So I need to wait that 120 days till we can get our master files to you. We get through the workshop and get our master files.
You can try that. It might work, but I'm saying that the problem may come in because the original master file is not corrected.
Well, I'd rather just go for the sure thing after the 120 days.
Play the trustee role and come in there and say, hey, you're right. I am the trustee. I'll agree with you on that, and I didn't make a payment. I'll agree with you on that. Now there's no controversy in here. There's no case. Case goes away. There's no controversy. I agreed with them. But if we're in the chambers here, and I'll tell you the reason why I didn't make the payment, because really you guys are bankrupts. Your beneficiaries are all bankrupts. I can't issue the funds to you from the trust because as trustee it's discretionary, and by discretionary trust it would defeat the purpose of the trust to issue the funds, because as soon as I did, the creditors would jump on the beneficiary's asset that I just gave them, and they would defeat the purpose. So I can't do that. That's why I had a legal right to withhold.
And is that because at the beginning of the year all these corporations have to borrow money to operate all year long, and that's what keeps them from that's what makes them continuous debtors?
Well, corporations or debtors, yeah, they can't do anything because they need a signature to do anything. They need a bond.
I think it was through Patrick Devine where they, for example, the utility companies, they borrow money, and that's how they operate all year long, and at the end of the year they zero their books, and that's why they're trying to balance their books by the end of the year, because it's all done based on credit, so they're debtors to who they're of course, every debt is somebody else's credit.
Operating on commerce is discharge on the public side.
Repeat that again?
Operating in commerce as a discharge on the public side, which is House Joint Resolution, that you should discharge your debts dollar for dollar. And that's what they're doing. But they're not allowing you to come on the private side and do the set-off, which is the relief valve, relieving the debt that's been established on the public side, because you have an established trust position. You haven't expressed the trust, and you're still a debtor.
Just like they are.
Creditor-debtor law.
Just like they are if they fail to express.
Yes, right. And here we thought we were doing a set-off, and we weren't. We were doing a discharge, and we never could touch the real assets on the private side and do the set-off because we were still under a debtor-creditor relationship. We never expressed it to be a trust, and here it was a trust all along.
So where do these CFOs and these internal financial organizations within the large corporations, where do they go to learn this stuff so they can learn that they really got to express themselves through trust so they can do discharge?
Well, I don't think they really have to, because GAAP has been training them. This is what it does, and they're following GAAP rules. But whoever wrote the GAAP rules knew.
So you think all these CFOs don't really understand it? They just follow GAAP?
Yeah, because GAAP is you got discharge according to bankruptcy. You got set off. You got all that stuff on there. It's all according to the rules. Now, I think once we get this going, once we get established and get some knowledge in here, I don't believe you have to even go mess around with banks and in courts and all this other stinking stuff. Because I'm going to call a Treasury directive hearing and ask them, the IRS, to go straighten all this mess up. And the only way I'm going to get them stuck in court is if somebody drags me in there.
And then, of course, you would turn the case into a trust at that point anyway.
That one, yeah, I've been turning that case into a trust and putting it in special deposit and sending it to the IRS and asking them to come back at this court and settle the matter for me.
And at this point, all the courts operate in commerce, so it really doesn't matter whether it's a a crime against a person or whether it's a crime against the state, because the state is going to be the filing party anyway.
Right. All commerce is debtor-creditor. It's not trust. Not
but
private
even for
trust, that way.
But even for example,
trust operate in debtor-creditor, but private trust does not.
Right. So if you walked into and expressed the private trust through, and what we're talking about here under private, we're talking about constructive trust, right?
Yeah, you got constructive on a private, yeah. Mm-hmm.
But do you think that that's most commonly the way we're going to express that is through the operation of constructive?
If you want to call it a constructive trust, yeah, I'm just expressing a trust. Let's put it that way. All trusts operate the same way on the private side.
But I'm talking about for the purposes of what your curriculum is. Do you think that it's most often going to be expressed through the operation of a constructive trust?
You could call it that on the private side, yeah.
Okay. Because in the key areas of study that you had a study on that document that you sent out, that's what's on the page, and from everything that you're talking about, it seems like it's kind of the default thing that we're all gonna automatically walk into in doing this operation.
Right.
And do you see of any other type of trust?
Trust is the legal fiction that you must put on to walk into the public under a public constructive trust, which is the face mask of the straw man, the fiction.
Now, do you see of any other type of trust that we might express by default, even with our awareness, but express by default because that's the situation we find ourselves in, decide constructive?
Well, I'm kind of looking at all those trusts being the same. You know, they're all either a black trust or a white trust. They're either going to be a public trust or a private trust. Whether you call it a resulting trust or a discretionary trust or a protective trust, you know, there's just a little bit of different wording in the indentures. They're all basically the same trust on the black side. They're all basically the same trust on the white side. So really, I'm only talking about two different kinds of trust. It's either a public trust or a private trust. I'm trying to reduce everything down to its simplest terms so I don't get, you know, and once I understand the model based on the simplest terms, then we can complex it up a little bit and we can mix it up and match it a little bit. It's like if I take nothing, if you visualize nothing, divide a line down between it, and what have you done? You've created something and nothing, you know, anti-nothing or anti-something. But when you put the something and anti-something together, you've got nothing. A mind bender.
Yeah, it is.
It depends whether or not you value something as something and nothing as something. Really.
So to bring up the terms of discretionary or constructive, that's really the next level up from the most basic. It's really the most basic way to look at this is either black or white.
Yeah, so they took the black and they divided the black, and now they got a constructive trust and a resulting trust. Then they drew a line down again and they made it into something else. And they keep dividing the same thing, but they started with the original source, which was really just one, a black. And they keep dividing it. And they divide it kind of like hide it. Because if you ever got the model down to the simplest terms, you'd see that everything's just black and white. That's it.
Can I make the suggestion that you create that visual model for us for the workshop?
Yeah, if we draw a circle and draw a line right down the middle.
But as far as what results from the different operations and how we might find ourselves in those situations.
Well, the circle without the line is the perfect title before 1933. And then all of a sudden I drew a trust line down the center, and now I got public and republic. I got public and private. I got plus and minus. I got a trust on one side, and I got a public and private trust on the other side. And really, that was a ledger sheet. If I drew a line down on the bottom, now I got that T count. All I got to do is create a title on the left side, create a title on the right side, which are the two charges, and then draw a circle up at the top, which is really the straw man account, and then merge both those titles up into that straw man account at the top. And what happens when I merge plus and minus? Set off.
Set off or discharge?
Well, discharge is in the public, and set off is on the private in equity.
Now, are there multiple definitions for the word republic?
Well, I think that's public. Again, public. Like lease and released. First you're leased and then you're released. You're sent back from where you came from. You were released. So it was really a leasehold to start out with, and you were leased into the prison, and then later on you were released and sent back to where you came from. So it's like public and republic. Public is a body politic.
That makes you think about, does that same exact operation take place from when we go from our Democrat and Republic people in office?
Look at the way it's acting. Does it walk like a duck, quack like a duck, and we call it a dog?
Right. Does it keep swinging from one to the other, as you just described?
Yeah. So don't pay attention to what they say. Look how they're acting, because how they act, you'd be better off if you closed your eyes and listened to what was going on, and then you could hear, and then you could see.
Now, once we are able to get our IMF file changed in the fashion that's our goal, and we have control of that account, then we can start bonding our public officials locally and on a state and national level as well. And have you thought about utilizing that operation as well to recapture our republic as part of the big plan?
Yes, because we're going to terminate the trust by eliminating the purpose of the trust, which is going to bring the republic back. But you're being prescribed under a prescription, which is the act of establishing a authoritative rule, and is also the effect of a lapse time in creating a right, creating and destroying rights. So through the effect of lapse time in creating and destroying rights, it's the extinguishment of a title or a right by failure to claim or exercise it over a long period of time. That's the definition of prescription. So they're going to bleed the trust dry under the bill of equity, and they're going to give the credit or the assets to the creditors against the beneficiaries. Now, how do we stop that before it's too late? And there we look under acknowledgement of debt under Black's Law, which says the recognition by a debtor of the existence of the debt. And an acknowledgement of debts interrupts the running of prescription. Want to stop this whole thing dead in its tracks? Acknowledge that you owe the debt.
And the controversy.
Yes. And that'll interrupt the running of the prescription. And they will not destroy your rights through the lapse of time, because you failed to state the claim and express the trust. The claim would be, there's a trust here, and you didn't claim it.
Are we talking about the city key trust?
Any trust. I'm talking about the SETI Key Trust, to get all the assets that's in that, but really I'm talking about the private side assets that they took and they've invested and all the investments coming with that. we want to do an acknowledgement of the debt. And an offer to do with settlement, offer and settlement.
Are you doing that to the Treasury?
Yeah, for a Treasury directive hearing, yeah. 25-06, DIB hearing.
But when you're talking about acknowledgement of the debt, you're really talking about what the Messiah did when they nailed him to the cross. He said, "I acknowledge the debt, and with my sacrifice, I pay."
Yes. Mm-hmm.
And the controversy. So if once
redemption.
we acknowledge, yeah. So the lesson was really taught to us a long time ago. They just made it a whole lot more of a maze now to figure out.
Yeah, we've been brain dead for so long. Yeah, we got to start waking up.
So of course all the elements were there in the Wizard of Oz with the cowardly lion, because all he really wanted was courage, and that's one of the things it takes in this to be able to deal with.
Notice what he got in the end. All he got was a public recognition of something he had already. He got a certificate, which was a public recognition of something he had already. You've got it already. You just need them to recognize through the right actions and give them the orders then, and you can get back to Kansas.
Right title and interest.
Say again?
Right title and interest.
Yep, trust.
Now, I think it was maybe Saturday or last Wednesday you did a study on some words about the I'm trying to think about, I think you used the terminology of they transport, and how I think you were actually talking about the word trust and the different meanings of it. And we can think of it both as a noun and a verb.
Yes, right. Mm-hmm.
Now, when we're talking about what you're
really the relationship of the trusts is really not the building down the street that houses the grantor, trustee, and beneficiary. No, it's the relationship between the parties. I was talking about interest. What is your interest in this case? Well, my interest in this case is $500. And you look at me strange and say, well, interest is $500? Why do you say that? Well, I loaned him $500. Oh, you mean your interest is you loaned him something? No, my interest is $500. It's like it's relative to your point of view unless you have a starting point that establishes, which side is which. And that's what I was toying with back when I was talking about set off versus discharge. Could be either or, depending on what it was. And we didn't really have a starting point until I thought, we do have a starting point. It's really, House Joint Resolution 192 says it's discharge on the private side there. So the opposite on the other side has to be the set off, and that has to be then the private. So that established that fact.
And to take that into this whole realm of what you're talking about, that $500 would also be which would be our interest, would be our trust res in that context too, right?
Yes, if that $500 consisted of all 20s and I asked for the 20s back, I want those specific trust res back. Segregated deposit, special deposit. In kind in, in kind out. If I requested a special deposit, that's what I meant by my pen, because really it's the intent and purpose of the grantor, who is the law of the case. And since I'm still alive as grantor, I can express my intent if I ever had to, so I don't really need a whole lot of wording to set something up. And they're only going to be able to construe it when I can't respond or else I'm dead. Now they can construe whatever they want because the parole evidence is not there, the oral evidence.
And when you use the terminology of "I'm dead," are you referring to when they bring your straw, when they recognize you as the surety for your straw man in a legal proceeding?
Well, I think he's dead year to year. He dies. He's been dead, and he dies again year to year.
But
So
that's
we're
what you
continually
mean.
closing out the books and starting over again in the new year.
But that's specifically what you're talking about, because when we go for a legal proceeding, they always call you by your last name. They never call you by your first name because they're not
So I
talking
got
to you. They're
the straw man as the straw man and give the colorable lies that they want to hear, but yet, keep the truth, which is the real substance and stuff in the chambers. And there I'm speaking my language in chambers, but I'm speaking a foreign language outside of chambers, especially when I'm talking in the fiction land in the public.
And of course, the fiction is dead, so that's exactly what you're referring to.
So interest is going to mean one thing to the public, but interest on the private side is going to mean something whole different. Because my interest is going to be my $500, but on the public side, they want to know that, well, what is your interest in this case? Well, I lent them something. Well, really, the lending is really the $500. So it's relative to the point of view. But you got to have a starting point to set what side's which.
But of course, on the public black side, they can't even recognize what your real interest is because they can't recognize you as the white. They can't.
So why tell them? Because if I do, I'm going to waive it. I'm going to waive it if I tell them. Why waste my energy trying to educate something they can't listen to me?
And of course, they have their policies that they have to operate by, as you expressed earlier.
Yeah.
So they
I can know those rules, those procedures, and those forms that they use, and then I can manipulate that puppet and get my results that I want. Because now I'm in control of both sides of the ledger, public and private.
From the white.
The private controls the whole thing, from trust position. Because I've given you guys everything, that's my trust. But have you guys breached the trust? Or is it that I just didn't express it to be trust?
And if you just think about it from man to man, if we don't express trust between one another, what do we really have? We have nothing.
Nothing. Yes.
So it's really no different when you go to court if you don't express trust.
Trustees kept the property and didn't give it to the beneficiaries. Is there anybody out there that was on the trust? Were you on a trust call Monday?
Are you asking me, Christian?
Yes. Was there anybody else out there?
I was not on the trust call Monday. I haven't been invited yet.
Okay. Anyway, the document we're studying on that one was a practical treatise on the law of trust by Lewin, 1888 book, 2 volumes, like 1,200 some pages for the most of it. And we spent like 2 hours and got through less than a page and a half, something like that. But anyway, I asked anybody if they read ahead, and somebody said they read like up to through chapter 3, which is like the first 30 pages. But really what I was after was, did you see what I saw in the first 20? And nobody really spoke up. But if you saw what I saw in the first 20 pages of that book, you'd be jumping up and down. So I would encourage anybody, to get that. You could do a Google book search on that and pull that up. 2 volumes. But within the first 20 pages lays a blueprint for all this stuff that they've been doing for all these years since the formation of this country. And that version, 1888, was based on the 8th edition of the English version. And this 1888 was supposed to be, it says in that, was the first American version. And it's nothing more than a blueprint of what's been done already and how they're doing it. Not a theory. It's exposing for what it is. Talks about the subpoena, and really talks about the how-tos in there. So, any other questions?
all we
On
got.
the Gilberts, you've talked about a 2008 and a 2009. As long as we get the 13th, that's what we need, right?
Yeah, I don't know if there's a 2009 version. I've got a 2008. But I think when you look at that ISBN number, you get it says it's a 2007. But when they send it to you, it's 2008.
Because there's a bit of confusion, all that matters is it's the 13th edition, right?
Yeah, 13th edition, yeah. Yeah.
Okay. And a lot of us have that PDF of that instead of the actual hard copy. As far as for the upcoming workshop, are we okay to have that PDF and that's going to work fine? Or
I don't think so. I haven't looked at that PDF of what all the way through. But what I've seen in there's missing things in there. I don't trust it. Either somebody didn't copy that and scan that right, they left some things out that are pertinent, or else maybe it's disinformation. I don't know. So I'm not really endorsing that at all. I'm saying get the book.
You can get them on Amazon.
Only less than 30. Yeah, it's less than $30.
Yep.
And as far as one of the things you said we need is a Black's 8th or 9th, the latest one. I think it's the 8th you said. But I have a 4th.
They do have a 9th.
But I have a 4th, and for those of us that have, we don't have the 8th or the 9th, are we still going to be able to keep up pretty well?
Well, I read a lot from the 8th, so I use that primarily. But then I like to compare the older ones and see how the definitions have changed, especially pre-33. Now we do have digital copies that are going to be available, like on the 1910 version. That's First Blacks. That's going to put us right around the book, the trust book there at 1888, about the same years. Yeah, but even the newer 9th edition, even a paper copy, if you don't have a more modern version. Paper one won't be bad. I don't know what the hardback is, but I prefer the hardback because I wear them out.
Is the 4th modern enough, or is that still a little too old?
4th, that's about 50s, 60s, right in there. I got a revised, which is 8, I think.
Yeah, it is 50s, 60s.
Yeah, the definitions are not there as on the 8th compared to the 4th. And that 8th is more close to what they're doing right now because that's our modern times, how they've construed it. And that's where I'm getting a lot of my information from, the Black's 8.
All right. Well, that's what we need to know because I want to make sure that I'm right there with you every time you're talking about something. And please post that ISBN number for the UCC with official comments that we need to get, so I can get that ordered.
All right. Well, I'll give you the number. You got a pencil?
Yeah, I'm ready for you. Shoot.
It's 13-978-0-314-18112-1.
Thank you, Christian.
What's that ISBN for, Christian?
That's Gilbert's Law Summary Trust.
Oh, yeah.
Oh, no, I needed the UCC with official comments that we need for the workshop.
Oh, that one?
Yeah. Because there's 3 of them that I found, and I'm not sure which one you need.
The one I've been using all this time is a 2004 edition, which is kind of outdated, but I keep on using it because I got so many markings in it that I got to use it. And I haven't got a newer one. So just get a newer one. I don't think you'll be able to get a 2004 edition.
And as long as we get it through, is it Thomson West, I think is the publisher?
Thomson West, yeah. Mm-hmm.
All right, as long as we get it and it's published by them, 2004, no, we'll be good.
It's a Thomson West UCC with official comments?
Gotta have the official comments. Don't get one without the official comments, yeah.
Okay.
Yeah, mine is entitled Uniform Commercial Code 2004 edition, official text and comments. Okay, any other questions?
Hey, I have somebody who sent me an IM, and if the host could tell us how we can raise our hand or unmute to be heard, that would be great. I tried that earlier and it said that feature wasn't available.
You know what? Maybe it's star 8. I apologize. I've probably been saying star 6. It's star 8. Yep, now they're coming up. All right.
Maybe that's why you didn't have so many questions when you normally have a lot.
It's been a long week.
I understand. Well, we'll have to put that information.
Thank you. I should put a big sticky note on my monitor here. Star 8.
It gets a little confusing jumping from call to call with different call board numbers and stuff in sequence. I know how you feel.
Yeah, we have 5 more callers here. I don't know how much longer you want to go, Christian, but Massachusetts, you've been unmuted. If you had a quick comment you wanted to.
Yes, thank you. I just wanted to jump back to the 2 volumes that Christian mentioned, 1888. What were the names of those again, Christian?
The names to that? The title of it is A Practical Treatise on the Law of Trust.
Practical Treatise on the Law on Trust.
Of Trust.
Law of Trust. Practical Treatise on the Law of Trust.
Correct.
Okay, thank you.
It's the 8th edition, and it says it's by Frederick A. Lewin. It's Lewin. It's Volume 1 and Volume 2. Volume 1's easy to find. Volume 2 is a little harder to find, but you can still find both of them there. Google book search.
Frederick, what's the last name again?
Lewin. Lewin.
Yeah, okay. Thank you.
This is the first American from the 8th English edition.
All right.
1888, Boston.
My hometown.
Christian.
Yes.
Okay, this is Marco from New York. Can you spell that Llewellyn's last? How you spell that Llewellyn again?
Lewin.
Lew.
Lewin.
Lewin. Okay, I thought it was Llewellyn. Okay. All right, because that's what I wanted to ask. And another thing. I spoke with you last week. We were talking about getting you were going to send me the certificate of deposit. And I hadn't gotten it yet, and I was wondering what if you had forgotten about me there.
No, I sent it out to some people who requested it, and I thought I gave it to you.
I got it.
No, I never got it. So if you could send it to me, I'd appreciate it. Just send it to marjcks@gmail.com. Got it?
Did you send that to him, Matt?
marjcks@gmail.com.
Yep. I'll take care of that.
Okay.
Thanks.
Okay, that's all I needed. I hadn't heard from the judge again. But I don't expect to hear from him just right now either, because he's basically trying to get out of things. But I want to keep this, like I've been listening to you about keeping it private, and have your communications go basically eyes only to the judge regarding it, so it can stay CCI. And the only thing you put in public is the notices, and at least I remember that much. So the only thing that's in public is a notice, but all documentation and all of the trust rests, the property that was given to him was done privately. And it's interesting enough, he hasn't sent it back. I haven't heard anything. He has to process those documents. If he doesn't process them, he's holding them. He's going to convert them. So I'm not fretting it. You just got to give it the 30 days, and 30 days, I believe, is up yesterday. So I'll wait and see.
Okay, great.
I did note on the trust was expressed. They got UCC1, got a filing. The county doesn't want to do things here, so I did a UCC1 filing at the state. And then I'll take what I get from the state and then go to the county and do it as something else. You know, I'll figure out a way to get it in there. But they only accept real estate here. If it doesn't involve real estate, they don't accept the UCC1 here at the county. You have to go at the state level.
What do you mean they don't accept real trusts?
No, not the trust. UCC1s.
That's what real estate is. Estate means trust.
Yeah, they will accept
Real trust.
I'm sorry?
Real estate means real trust. Estate means trust. It's a real trust. We've been scammed along with the definitions. We don't know what the definitions really is. When we come back to the original words and figure out what it was, what it really means, man, it's a shock. Real estate means real trust.
Okay.
What do you mean they don't record real estate?
It doesn't involve a home or real, immovable real property. They don't want to take a UCC. It's the same
ask them if they record deeds. And keep in mind that a deed is a recording of an act. That's what a deed is.
They do real estate, deeds on property. Yeah, they do.
Well, if I had a declaration, which was an act, you mean to tell me you don't record deeds of trust?
Well,
is my real estate my real trust?
So what I will probably do is put it in a document that the information that would go in the UCC3. I mean the UCC1 when you file it in the county. Put it in another document because if I put it on UCC1 form, they won't take it.
Okay. Yeah.
So I just get the information and file the information.
The reason why they're saying they don't take it is why? Because it's just a notice. It's not real estate.
Well, I guess this is all part of their fight against the patriot movements, I guess. And that's why people all over the country having problems with these county clerks filing their documents. They getting together to try to shut us down, and then what they tend to do, they jack the prices so high up. If you file one document, it can cost you over $100, man. To file it, you file a document is $35 and plus $5 per page. So you file a 10-page document, you just out of almost $100.
Yeah, well, that's where we need to our account and get the interest generated off the private source side, and we can just write a check for any amount that they want drawn off the interest because it's converted already to Federal Reserve notes, and there's no question.
Amen to that. Teach us how to do that, Christian.
Yeah, we're trying to get there. We're trying to get there.
Yeah, I need to get there. I'm not there yet. So, actually, when you mentioned that, my mind went tilt. But eventually, we do need to get there. So I'm willing to be patient and learn. So it's all a learning process for me, and as I go through this, Now,
well, the height of the building is established by the size of the foundation. And the size of the foundation is determined how long you work on the foundation.
And that.
I intend to. No, I usually have a meeting on Wednesday, so I come into the meeting a little late. So I know that you probably discussed this, but someone mentioned about the workshop. You have a date and a time and a place for that already?
Yeah, if anybody wants to check out my website, I just put it up last Saturday, the 16th. The website address is, plug this into your browser, movingtitles.com. If you go into movingtitles.com, it'll come up with the home page, and it gives an explanation of the formal announcement of the workshop, which gives the details of the workshop. The workshop is, I'm going to modify the page a little bit and bring it out a little more clear. It really boils down to two options. Option one is $299 for one workshop, and the second option is a savings of $100 or $498, for two successive workshops back to back. So you could purchase two back to back and save $100 or $50 each workshop. Each workshop runs for 2 sessions per week, and each session is 2 hours, so that's 4 hours per week, and it runs for 5 weeks. So that's 20 hours total.
You're going to do
that's
it electronically, or you're going to do it face-to-face?
I didn't hear you. Say again?
You're doing it electronically, or you're doing it face-to-face?
No, this is electronically. You can access it through the web. It's a webinar style. We're going to do share documents on the web, and then it'll be a conference call line separate.
Yeah, and I tried to do one of those webinars, and I had more headaches than it was worth. I mean, more problems with computers. So I was hoping you might do a face-to-face one. So.
Well, I plan on doing 4 seminars a year, which would be live. But I don't classify them as the workshops.
Mm. Okay. When is this webinar going to be, by the way?
Well, I'm taking registrations right now, and then the webinar is going to be starting probably, in the next couple of weeks. I haven't really set the date, but it's tentatively set for Mondays and Thursdays, at 10 p.m. Eastern Time.
Okay.
Check out the website at movingtitles.com. It's got the information on there. And then I'll be updating that all the time, so keep checking back.
Okay. All right, will do. I don't know if I'm on the list for your Tuesday night calls. I know I've been calling on Wednesdays. I'd like to get on your list for that.
All right. Just send me an email at the Hushmail account, movingtitles@hushmail.com.
Uh-huh.
Can put you on the list.
Okay. All right. Good enough. Let me relinquish the line for somebody else.
South Texas, you've been unmuted. Go ahead with your question.
Hey, Christian.
Yes.
Hold
on just a minute. I'm going to give the number anyway to get on a Tuesday night one, which is, let's see, where's it at? Where is the Tuesday night call number? Where's that? Okay, the number for Tuesday night call is 712-432-0075. And the PIN number to get in is 917030 pound. So that number again is 712-432-0075. And the PIN is 917030 pound.
What time does that start, Christian?
10 o'clock Eastern Time.
You ready for another question?
Yeah, go ahead. Mm-hmm.
South Texas, go ahead.
Hey, Christian, how you doing?
All right.
I'm glad to know that I wasn't given the back of the shoe off this conference. Couldn't get in, pressing the wrong numbers. It's been an hour and a half, so I already forgot the questions except one. Are you getting close to teaching trust termination?
Well, really, in the workshop, we'll be working on the documentation to terminate any trust, and it's all going to be really the same.
Okay.
One trust is the same as another. They all operate on the same principles.
Because I think I came in late on the call, and I heard you talking about terminating and revoking. So I just thought you might be in that general vicinity. But you're almost there, right?
I didn't hear you say that again.
You're almost there.
We're getting closer. Yes. Yeah.
Okay. Sorry about the questions. I forgot anyway. It's late for you guys. So thank you very much, Kristen.
Thanks for coming on.
Thanks for joining us.
You bet.
North New Jersey, you've been unmuted. Go ahead.
Yes. Hi, Christian. Bill from New Jersey.
Hi, Bill.
Hey. Question about assigning or appointing of the trustee. Now, tonight you were talking about how the trustee can be, he can refuse appointment. At the same time, I'm a little confused about if we form a trust and no one has to know about it, does the person become a trustee by certain, we could say, well, you're going to be my trustee, but if he doesn't know about it, if he doesn't refuse, how does that work? You know what I'm trying to say?
Yeah, the trustee becomes a trustee upon present transfer of trust res property to the entity or the party. And really, as long as you give him notice that a transfer has taken place, he doesn't really have to have possession of it, but yet a transfer is still taking place. And notice really comes under, say, like UCC 1-202. Be really interesting if you got that to go ahead and check that out. Maybe on Cornell Law, go up there and do a Google search and read through 1-202. And it talks about, is the fact that if they sent you notice, and even though you don't know or understand or didn't even receive it, the fact that they sent it, that's the proof that you knew or understood.
Wow.
It's the record for the fact that they sent it, and that's what we're using against them.
Right. So
the trustee really know, although he has accepted by transfer, and he's sitting there holding, and he doesn't even know or understand that he's holding.
Okay. Yes, I think you did mention that before. I forgot that. Yes. Right. So the key is to change the titles, just to send a notice indicating that there's a property under his control.
Yeah, an assignment on a UCC 3.
Cool. Okay. Thank you.
Assignment on a UCC 3, it falls under number 2, which is transfer under one of the methods of formation of a trust. And also, if he did a green card signing on the presentment of that notice, that's also under transfer. That's under A, endorsement, because he endorsed it. And also it falls under B of that, which is delivery. He was delivered the notice.
Right.
So I actually got him under a transfer under number 2, the second method of transfer, method of formation of trust on number 2. You got him by A, endorsement, B, on delivery, and C, by assignment on a UCC 3.
How does registered mail fit into that?
Registered mail? Yeah, you could use the registered mail of the trust property to him, yeah. Of the notice, sending him the notice by registered mail.
Yes, I like registered mail. Okay, well, I couldn't reconcile how that works, but now you cleared it up very well.
Yeah.
Thank you. Looking forward to the workshop.
Another question?
Yeah, Eureka 11. You've been unmuted. Go ahead.
Hi, this is Al.
Hi, Al.
Hey, Christian. I raised my hand to recommend, but I think you guys got it covered already about putting the 1885 or 1888 book. You can download it from Google Books. I downloaded it to my hard drive, so you can get it for free there. I did it last night.
Right.
No, I'm glad that a lot of this information you're giving us is making a lot of sense. But we do have to do our part and learn the basics of what we need to do to make this our own information. So I think with repetition, we'll start making more sense of this, I think. But I appreciate your training and all that stuff and your knowledge base and all that. It's really, really a blessing.
Thanks, Al. Appreciate it.
Okay. Just keep up the good work, and we'll see how we can support you in any way that's possible. When do you think you're going to start the classes,
Probably about 3 weeks.
Okay. Meantime, we're getting more base, more of an education base, so that we can, I guess, move forward with more conviction of what we know.
Yeah, because the more we are knowing the basics before we go into the workshop, say, the better off we're going to be further ahead. And we don't have to go back over the basics again, talk about moving titles and platform, and talk about how to use a notary. Because those things are basic. We should have that down already. I want to talk about trust, but if we got to go back to the basics and talk about how to move titles and how to claim titles and create titles, then that's what we're going to have to do first. And how do you do a presentment, create a record? We got to know how to do that before we even get to trust.
Okay. Okay. I guess. Do we have any other things that we have to put in place before we can implement these changes we're going to be doing with the trust, like the UCC1 and any other documents we have to file? Wherever we may live, in our jurisdiction or our state or our county.
I'm not quite following. If we're going to, in what regards again?
With regards to the filing your UCC documents, I don't know if we have to do any of that, or maybe it's not a relevant question, I think.
Yeah. To move and claim the titles, we have to use the UCC, and the county for notices.
Okay. Okay. All right. Thank you.
Next caller, Central Coastal California. You've been unmuted. Go ahead.
Good evening, Christian. Two thoughts. Just one just came to mind. You have to have two places. Can you have a UCCs in two states? Does that constitute two witnesses? For example, my original files, UCC ones, I did in Texas, then I did it in California.
Yeah, you could have a multiple states and bring it in under the evidence rules as being public records. Yeah.
The second question is how do we? I had a phone trouble earlier. How do we get this the TalkShoe recording?
Are you signed up with the Free Americans?
Yes.
Do you get the Wednesday reminders for our calls?
Oh, fantastic.
Do you get that?
Yes.
In that email, there's a link at the bottom to the TalkShoe website.
Okay.
That'll bring you right to the 41875, and all the recordings are on there, and you can just go down and click the one you want to listen to. Either
fantastic.
Listen to it right online or download it. Yep.
Okay, excellent. Thank you.
You're welcome. Next caller, Daybreak. You've been unmuted. Go ahead.
Okay. Also, the other recordings, if you send me an email request, I'll give you the links for the other recordings on the other shows. So.
What's that email again, Christian?
Let's see. If you send me an email request at, say, Christian@movingtitles.com, or you could send it to Christian at excuse me. Well, I forget what it says. Christian@movingtitles.com. That's my main one now. So, but you could also go to let's see, movingtitles@hotmail.com. Got too many email addresses now. Can't remember.
Yeah, trying to keep track of them all. Yeah. Christian@movingtitles.com.
Yes, either there or send it to movingtitles@hotmail.com.
An easy one to say, and
people know how to spell moving titles.
Hey, Christian, it's JC.
Hey, JC. How's Arizona?
I was JC near Arizona, absolutely. Yeah, it took me a couple hours to figure out how to get on here and get the unmuted part because, yeah, there's 5 different systems to work with. So anyway, thanks for tonight. Yeah, the first 20 pages, I have to parrot that. I've read it through it twice. I think I need to read it about 5 more times because it's all in there. I think if we do nothing more than that, it's staring at us in the face right there. That's just my commentary.
Yeah.
But the question from, I think it was maybe last Wednesday's call, there was a gentleman on here who talked about getting the Declaration of Independence apostilled, and I don't know if he was talking to you about that. Do you have any update on that, or how he did that, or what he did with that? And did he have an allonge with that, or did you just send it in and get it apostilled without the allonge, which wouldn't make sense?
I don't know. I haven't heard back from him.
Okay. Okay, that was it. That was my question.
That was it? Okay.
Well, that's it.
I don't have any information on that, how that turned out.
It doesn't make sense to me that you'd even bother doing that until you get the allonge sorted out properly.
Yeah, right. Uh-huh.
Okay.
Next
well, thank you.
I got another one?
Nope, that's it for me.
Yeah. Well, let me ask you this. What anything particular out of that 20 pages that really sticks out?
I went through and I have blacks first, and I did an OCR on it. I put it together. I'd like to send it out, but it's about 350 megabytes, so it's kind of hard for me to transmit. But just going through and looking at the words, and the words are different than they are in Black's 8th, and I think that's appropriate. You know, I was listening to some other lady, I can't remember her name, Beatrice perhaps, and she was talking about the Constitution as the trust and the preamble specifically. And she was going through with Webster's, I think it was an 1886 dictionary, and because that's essentially as close to when they were using the words back then in the same type of concepts. So I think Black's first was back in 1896 or thereabouts. So anyway, just going back and forth with the words, it just struck me that, the words and the terminology is quite different than Black's 7th, which I'm using in hardback format.
Oh, yeah, right. Big difference, yeah.
So even if we try and interpret it using a Black 7th or 8th or something recent, we don't really understand what the 1888 document is putting forth until we can go back and understand it with that terminology. So it takes a lot of time to go back and take your notes and move that thing forward.
Right. I mean, even if you just do a cursory read of that first 20 pages, even some of the words that are foreign to us that we're not aware of, that we don't use anymore, but there's things in there that just jump out at me, without even doing a further study. Like the how-tos are right there. Like the subpoena. The subpoena was actually subpoena was used to subpoena in the real man, and the summons is really used to subpoena or summons in the fiction. So they summons in the fiction with the main complaint, and then whoever shows up, the real man. So we should be mirroring the same thing. From that point on, they don't use a summons, they use a subpoena. And once that entity came in, that real live man, then they subpoena him from then on. But then we don't do the mirror opposite of that. We don't come back in and do a summons as a counterclaim and bring their corporation in on the counterclaim. And then whoever shows up, then from there on we use a subpoena, and we subpoena them into in-chambers. The subpoena was designed to summon the trustee in chambers to answer to the beneficiary's claims why he didn't make a payment. Why didn't he distribute the funds? So that
I have a little bit of
that's part of the device to use a subpoena.
Yeah. No, that was brilliant. I had a little bit of a setback today in that I got an order back from the court saying that they were denying the petition for CCI, and so anything that has been put in there, not sent to chambers, but actually filed with the clerk. So I guess as a learning point, you can't trust that the judge is going to listen to you. I can always take that to the appellate court on an interlocutory, but the judge denied that motion today to as a protective order. So the gentleman that was talking a little bit earlier, you're doing exactly the right thing. You got to keep everything on notice. You put nothing into the public. And some of these documents were from UCC recordings that were done years ago. They're already in the public. I can't take them out. You can only redact them with a court order. So, what's in public, and it's almost like when the bell has been rung, you can't really unring it. That's kind of an old saying. So, anyway, I have to work around and just what I want to do to quash some of that CCI about the 14th Amendment citizen, non-14th Amendment citizen status. And because that's how the IRS is doing business. That's how the confidential information is put forth.
Right. State secret stuff.
State secrets, exactly.
They can't reveal it diplomatic information to the general public. Yep.
But one thing that came out of that, though, is I realized that to send a money order in and do that by transfer, registered private delivery with a green card, you have your and then so you'll have assignment, you have endorsement, you can deliver, you can pick whatever method of formation you want because you have 3 or 4 of them in there. But sending money order into, say, for example, Allison Doon, the CFO, so that has been effectively transferred. And then if anything arises, you can do a counterclaim and a summons, because you have to send a summons out with any counterclaim and any pleading. And then the next thing is when nobody, which they won't, they might send somebody from the DOJ, then you subpoena in that person to whom you transfer the document, i.e. Allison Doon, see it get on a plane, fly from and appear in the living flesh. How inconvenient is that?
Right.
I love it. It's about time. So when I was reading through the summons and subpoena part of it, I thought, this is fantastic. This is turning the tables. We're going to inconvenience some people because it's turning the tables.
Beautiful thing.
The beautiful thing.
Great. I'm here. I'm glad to see somebody else starting to see it. Anything else?
Not tonight. Thank you.
Okay. Thanks, JC.
Thanks, JC. Well, that's all we have for tonight, Christian.
That's good. I was getting tired.
Yeah, we went extra long tonight. We normally don't go much past 2 hours. We've gone 3 hours and 15 minutes tonight. So.
Well, I think this flushes out the a lot of the questions. Everybody is repeating. Basically everybody's got the same kind of questions, but it's. If you could go to the downloads and get some of the past shows and things and go through some of the recordings, you're going to probably find out that your questions are probably answered somewhere along the lines in there, because we're getting a lot of repetition of the same things all the time.
Yeah.
And let's face it, some of this stuff is a little higher level, and you're jumping in onto some graduate class stuff that's, really you need the basics under you first. Because it's like jumping in on something, you know, where are we, you know?
Well, I think our Wednesday night calls probably focus a little bit more on more of the elementary stuff, whereas some of your other weekly calls are a little bit higher level.
Right. Yeah. Tuesday was more of a Q&A. This was more like a basics for the book. Saturday's a little more higher level. So we'll just keep on attacking and doing the best we can. So anyway.
Exactly. Well, thank you again, Christian, for coming on and teaching us and repeating. Sometimes being a teacher is the best way to learn, too. Well, we're going to formally end the call tonight, folks. Thank you, everyone, for joining us. Look forward to having you all back next week. Have a great week, everyone. Thanks, Christian.
All right, everyone.
Night.